Hi, good morning, everyone. It's 10:32, and we're going to start the public hearing notice. Sorry for the slight delay. We wanted Olelo to be set up. On November 13th, 2012, the public hearing is now called to order. My name is Lloyd Hariguchi, and I'm the Executive Director of the Public Land Development Corporation, and also the hearings officer for this formal public hearing. I'd like to introduce here on my right, we have Bobby Bunda, who's on our board, and William Aila, who's also on the board. The other board members had intended to come, but due to Chapter 91, which governs a public hearing, we could have two members here for this hearing. Also to my left is Randall Ikeda, who's on the staff, and also Joy Kimura on my far right. First of all, the women's bathroom is just outside the door, and the men's bathroom across the foyer in the other building, the adjoining building, the Kalane Moko building. There's an attendance sheet out front at the door on the left, and also we have the testimony, the sign-up sheet right here in front of Randall. So if you haven't already, please sign up. Thank you. The notice of today's public hearing appeared in the November 12th, 2012 edition of the Honolulu Star Advertiser. And this is in compliance with Chapter 91 on public hearing. The purpose of this public hearing is to give the public an opportunity to express views and opinions on the PLDC's proposed Hawaii Administrative Rules, Chapters 13-301, Rules of Practice and Procedure, and Chapter 13-302, the Public Land Development Program. Now, this is a public hearing, and we will not be answering any questions at this time. Testimony is to be specific on Chapters 301 and 302. I do want to ask all of you here to be respectful of all others that will be testifying here or in the audience. So with that, would like to start the testimony. Rana will call out the first couple of names. Thank you.
Dean Okimoto, and then Michael.
Please state your name before giving your testimony. Thank you.
Thank you. My name is Dean Okimoto. I am president of the Hawaii Farm Bureau Federation and also a farmer, president of Nalo Farms, Inc. I am here today to testify in support of the Administrative Rules, Chapter 13-302, 301, and 13-302. I'd first like to say that I believe the PLDC is an entity that can do much good for the state of Hawaii. I think we must give it a chance to see what types of projects for the benefits of our citizens of the state of Hawaii can be derived from this entity. The state should look at everything to drive our economy forward, especially when it can help the people of this state. Of course, we agree that because this is a public land and public must have a process to vet the projects within communities, that's in place, and I believe that's part of the changes in here. The state should look at everything to drive our economy forward. A good example of the type of projects that I was looking at it from the point of view of agriculture and what good the PLDC could do in terms of driving our sustainability initiatives that the governor has said. And one of the things that for years we've been trying to get is a biosecurity facility at the airports where we can monitor invasive species coming into our communities. I think, the state doesn't have the money to do it. We've been looking at this for years. Every year we deal with, as agriculture, as community, as the environment, about 20 new invasive species on average per year. By having a public-private partnership to build these facilities, I feel that we can mitigate a lot of these problems and not have the problems not only for agriculture, but for the environment that we deal with and even community with coqui frog. So you know, if guys are willing to invest in these facilities, I think we can increase our food sustainability going forward. And it is a major problem for us to deal with at all times. Another part for agriculture that we always have tended to be behind the mainland is having value-added facilities where farmers are able to take their seconds and produce other products such as ketchup, dressings, and all of these types of things. To be competitive and bring down prices of our fruits and vegetables, we do need these facilities to mitigate and help us to move the industry forward and make farming viable for our farmers. You know, the other things that I'm also on the early beginnings board, which is looking at the problem of early childhood education. I do believe that these types of things need to be moved at existing facilities where we can retrofit for preschoolers to go, and we have we have state facilities to do it. We need to do these things, especially with private input. Thank you.
Let me just remind everyone, and I forgot to mention that each testifier will have approximately 3 minutes, and depending on the amount of people that have signed up for testimony, we'll play it by ear. But thank you.
Aloha board members, my name is Michael Kumukau Ohali, and I have a letter to read from myself and Hank Fergestrom of Haleo Keawe regarding the Public Land Development Corporation. On September 20th, 2012, Nakapuna Moku o Keawe sent to you in public testimony the exact language clarifying that there are only 5 declared beneficiaries to the Ceded Lands Trust as defined in Section 5F of the Admissions Act. Such land proceedings and incomes shall be managed and disposed of for one of the foregoing purposes in such manner as a constitution and law of said state may provide, and their use of any other object shall constitute a breach of trust for which a suit may be brought by the United States. The Admissions Act in the Federal Public Trust created a federally enforceable right for beneficiaries to maintain action against the trustees. Plaintiffs 42 U.S.C. 1983 action thus proper 3F 3D 1220 period. The state's creation of the Public Lands Development Corporation is a contravention by law. The state of Hawaii is a trustee of the 5F trust lands and cannot simply bequeath the trust obligations to a third party, PLDC, without being in breach of said trust. The testimony, public-private, deprives the public of assets, lands, proceeds, and income by the inclusion of quote-unquote private parties as trust beneficiaries. Therefore, the public is subjected to unintended consequences such as suits that may result from failed agreements of the PLDC has already entered into with private parties. We have attached our testimony sent on September 20th, 2010, and hereby give you a second judicial notice of breach of trust. Respectfully yours, Hank Fergestrom and Michael Kumukau Ohali. Mahalo.
Aloha, my cousin William Aila, Mr. Hariguchi, Randall. My name is Lancelot Ha'ili Lincoln, Ku Mo'ali, direct descendant of Kamehameha I. I am Nakiki o Hawaii Lahul. I have a very big problem with the PLDC being PLDC was not created for the people, by the people. I'm suspicious of this group, PLDC. We all have to follow the law, even the governor. The Corporation Council on the Big Island has foreclosed on 2 of my family property, the Haile estate, 3 years ago because of old land taxes, and still has not given my family the monies for this land sale, which is way over what our family owed on our land taxes. Now, you see why I have a problem with this corporation that you have created, the governor has created here. They already have a corporation here stealing from our people, you know. Today it seems like, excuse me to all the white people here, but the same thing is happening to my people that happened to our queen back in 1893 as we speak. Very rich, white rich businessmen, Mr. Abercrombie in France. They are stealing our land once again and selling us out. And we need to stop these kind of things. And not just help the Hawaiian people, but all of the people that live here in the state of Hawaii that made this beautiful islands their home. We should be inclusive, not exclusive. And that's all I have to say. Mahalo.
This is Fumi Bonk right here from the Big Island. Do you want this one? Okay, this one's for the filming. Fumi Bonk is from originally from Hilo, but she lives in Kamuela now, and she's my mother, and she's asked me to come up here and speak for her and told me what to say. She's been getting calls from the Big Island a lot this week, including a call from Moani Ke'ala'akaka, a former OHA trustee for 12 years. Moani was a trustee for Hawaii Island. And to go on record, both my mother and Moani Ke'ala'akaka want to go on record informing the PLDC that they went back on their promise to have hearings on the Big Island after they made changes to the rules and regulations for the PLDC. They had promised the Big Island people that they would be back to have a public hearing, and they feel slighted that you didn't go back to do that, and you're doing it on Oahu so that the people of the outer islands do not have a fair opportunity to comment on this body, this corporation. So I brought with it to put on record an article that Moani Ke'ala'akaka has written on the PLDC in her newspaper called Aloha, Aila, and I'll present that to you. She's already stated why she is opposed to this, and my mother and father, who is deceased, have spent their whole entire lives, not just on the Big Island, but through the state, working for cultural preservation and archaeological preservation of Hawaiian artifacts and history. My father served on the DLNR board for historical sites preservation, and if he was alive today, he'd be appalled at this whole circus. My mother came today to represent him and his philosophy on good public planning and on good conservation of the environment, but in particular, their work to preserve the history of Hawaii. This goes against every process that we have in place in Hawaii. And you know, I'm sorry to say that the creation of Act 55, it was just encouraged by many developers who have other private interest in contributing large sums of money to our public officials to do special projects to them. Moani and my mother wanted to assert the fact that there have been a lot of fights on the Big Island with developers coming in and wanting to fast-track development without the public's participation. One in particular that they know has been earmarked for this particular corporation's agenda is Honokahau. The project in Honokahau has been boycotted and fought for many, many decades. The people have spoken. They don't want it. And here you come with another little developer plot and scheme to force it back into their face. They have a lot of better things to do on the Big Island, like community-based economic development projects that are going on all around that island. If you really want to help, eliminate this, put all the funds into communities, and let them decide what they want to do. And that's coming from the Big Island of Hawaii. That's about it. Mom, you have anything else to say? You have anything else to say? Well, okay. That's my mother, and that's probably why she sent me up instead of her. You have it on record. Okay. Mahalo.
This is the entry to the record.
Keiko.
Yeah, I have my phone.
Director Hariguchi and members of the board, good morning. I'm Sheldon Zane, president of Zane and Associates. I am here today to strongly support not only the Public Land Development Corporation, but also the adoption of its administrative rules, which is, I believe, specifically the purpose of this hearing. I come from 20 years of experience in public-private partnerships. I've seen it work successfully at the national level, being involved with Army and Navy military private housing. I've been involved in the city and county with probably the largest public-private venture done to date, the development of Westlock Estates and Westlock Ferries, in today's project value of in excess of $500 million. But my biggest disappointment has been, although I've been selected as a private developer for 2 university projects, they never came to fruition. One was the Freer Hall dormitory, which was then morphed into a design-build contract, which the state eventually paid for instead of having the private developer pay for. The other one was the development of 2 community college campuses on the Big Island, where I'm from, which was not endorsed by the governor, and the land never released to those developments. Now, all the projects I've been involved in have been master planned and already designated as development sites. So, I think a lot of the concern is developing properties that may have higher value as cultural and other sites, but that has not been the experience in my case. These sites have been long planned for development, specifically for educational and other uses. My reason for testifying is I don't have a vested interest in any of this. I don't intend to be a developer. I just feel that my experience and my associates who have been involved in the sole consultant advising the Army and Navy on their military housing project. Another associate is the University Financing Foundation that was formed to assist Georgia Tech University and now provides assistance to development and filling of research parks throughout the country. I also have local associates associated with me, the long recognized and respected companies, including planning and design by Welchie and Associates, civil engineering and surveying by R.M. Towell, and architectural work by Urban Associates, who has done a multitude of public buildings. My interest really in the future is really in having PLDC succeed and provide to the state the requirements that are critically needed to support our aging infrastructure. If we don't have methods of financing our public infrastructure and capital improvements, we're going to be faced with a crumbling infrastructure. With respect to the 2 sections of the rules, I have prepared some comments and suggestions which I will leave with the board. In summary, as they say in Navy football, I think we ought to proceed at full speed in adopting the administrative rules. And that's the end of my testimony. Oh, yeah.
Keiko and then Mr. Kirk.
Before you start, Keiko, let me just remind again, and maybe some of you came in a little later, but this is a public hearing on the rules, and it should be specifically on the rules. I would appreciate that. And in being respectful to others that are here today, please no applause or excessive, noise or applauding by the crowd would be much appreciated. Thank you.
Aloha, Chair Hariguchi, and members of the PLDC staff and the committee members. I'm here today to not support the rules and regulations of the PLDC going forth or any other action going forth on the PLDC, to postpone any action on the PLDC until the repeal of the PLDC is done in the next legislative session. The state and counties of Hawaii have public processes in place to do everything the developers who created this organization want to do. The PLDC is an insult to our democracy. The people of Hawaii have not been informed of this public process that is taking place right now, or any of the other intents of the PLDC to, quote, exempt from all statutes, ordinances, charter provisions, and rules of any government agency the development of public lands. The people of Hawaii do not know this is going on, and they do not know that there is an attempt to privatize the sale of their public natural resources. If they knew and were given the proper information ahead of time in a democratic way, they would be here today outraged as all of these people are, who are able to come on a work day at 10:30 in the morning. The people of Hawaii do not work for LURF and the other developer organizations that will probably speak for the PLDC. There are so many conflicts of interest in this establishment of this PLDC. I had to actually expose 2 hearings, these conflicts of interest. And today, since I didn't have a chance last time, I will continue. You, Mr. Hariguchi, for instance, worked for most of your life for a large land development company called James Campbell Estate. For 25 years you worked for this organization. And other staff people like Randy Ikeda was hired to work for Dwayne Kurisu, who is also on the board of this organization as the one out of 2 public members that we have. Randy worked as one of Dwayne Kurisu's chief operating officers for AIO, the media arm of Dwayne Kurisu's corporations who brand and spin anything they want consumers to buy. Dwayne also is the multi-tiered corporate head of Kurisu and Fergus, one of the largest real estate development corporations and speculative developers in Hawaii. Now, these are the people of a 5-member board with a couple staff that you want the people of Hawaii to have confidence in developing our public lands. I don't know about you, but I don't trust this whole setup. To put a developer, his hired people for 15 years, Randy, you work for him, a developer for James Campbell Estate that has interest in the PLDC developments, and for, a politician who is able to do all the work for the private corporations because he's retired from the Senate. Okay, there we go. I'm going to have to continue this at another meeting, obviously. But, putting all I'll sum up. Putting all these little dots together for the public is going to take a while. And they're not informed. They're just not informed. You haven't sufficiently informed them, and there's going to be a lot of legal problems due to this. And you just can't rip off the people's public resources and get away with it. Mahalo.
Aloha, members of PLDC. One of the issues that is always raised at public hearings is whether you have already made the decision and this is all a smokescreen, or whether you're actually listening to what we have to say. So, specifically, HAR 13-301-6 says the presiding officer may set time limits and may restrict testimony to what is germane to the issue. We are discussing whether we should adopt those as rules. And yet we were told at this meeting that we must obey that. That the time limit and speaking to what is germane to the issue is being imposed on the speakers, and we're supposed to be telling you whether those should be wise to adopt in the first place. So it sounds like you've already made the decision, since you're already living by the rules that you want us to discuss. That is stupidity. So we favor repeal. We've heard from some of the previous testifiers, and we've seen from the screen up there, that PLDC will enable the state to repave parking lots, to clean toilets, and to build catch-up designing facilities. Now, if you can't do that without the PLDC, there is something really wrong with government. So when a law is passed, you pass it with an intention of doing something. What is really missing from this is what it is you're really trying to do. Not the ketchup making, not the repaving roads, not the cleaning of toilets. There is some reason the law was passed. And the public deserves the right to know what it is that you're seeking to do. Thank you.
Aloha, members of the PLDC. I'm Millie Lunny Trask from Indigenous Consultants. I participated in most of the legislative hearings last year and also with the Civic Club review of this, and I'm here to now present my testimony requesting further amendments. I wanted to start out by thanking you for including the language I'd recommended in the last hearing, because I was worried about how we were going to protect our burials, our heiau, our endemic species of plants, our medicinals, and our trails and access ways, and that is why I recommended language. Thank you for including it. I noticed that you also did not include several recommendations I made, but accepting the nature of the public process, I can live with it. I am here to make additional testimony in 3 areas relating to the rules. In the process of looking at the proposals in the Civic Club process, I came across recommendations that I cannot support. And I want to use now the exact example of the Hawaiian community I'm working with, who are the homesteaders of Waimanalo. They're right here in the bottom southeastern corner of the Ko'olau-Poko district. Now, proposed rule changes have been submitted to you saying that whenever a project proceeds in an ahu pua'a, that all cultural practices in the ahu, as well as abutting ahu, need to be assessed, researched, and thereafter consultation. Now, the Native Hawaiians of the Waimanalo homestead community own the energy resources upon which their homestead lies. And they have a right to develop those resources for hothouse agriculture, which is what they want to do. The proposed language that came in from Jocelyn Doan and others would mean that those homesteaders couldn't move until they did a resource assessment for all of Kona District, Kona Ahu, which is Honolulu, all the way down to Aina Haina, all of Waimanalo, all the way out to Kaneohe, Kailua Bay, and into portions of Ko'olaulua, for the purpose of trying to see if they can have a hothouse agriculture project in Waimanalo. They have to identify every person fishing, worshiping at a heiau, collecting flowers, planting taro, and then they have to go and have a consultation with them. Native peoples own these resources, and they have a right to address them in an efficient way. These types of proposals are coming in not to facilitate the PLDC, but to delay its work. They do not protect Hawaiian resources or Hawaiian rights, and you need to see through it and see what's going on there. 2 other proposals I make for your consideration. When I looked at Section 13-302-25, the submittals of the initial project proposals, I see that the language is tracking to the original draft of 2011, which was for one central project. Some projects like energy don't proceed in that way. You have an initial exploration phase, and if it proves up, then you proceed to a development phase. When you're dealing with energy, you have to break it in that way. It's not possible for someone dealing with energy like the homesteaders to come in and show you a plan, because they don't know if they have it or not. And if they do have it, maybe it will be sufficient for hothouse agriculture, but maybe it will not. So you need to address that. Secondly, I'm recommending that we consider some changes to the section relating to conflict resolution. I think you might want to take a look at Section 205 under the Land Use Commission. There we have the mediation language, which I think could be useful. However, if you do look at that, I'm recommending a number 4 be included, and that is picking up the purpose of the PLDC, because the PLDC must show that any development that it undertakes and participates in brings an economic, social, and environmental benefit to our people and the people of the state of Hawaii. And so I think that that requirement must be added to the criterion that we now have in Section 205. But it's something to think about, to expedite time, and to save money. Thank you.
Good morning. My name is Mahina Martin, and I've traveled here today from Maui to testify on the PLDC's draft administrative rules. Like today, when the PLDC came to Maui for its first public hearing, we were told no questions could be answered. We were greeted at the door with stacks of paper to read and a chance to comment. There was no presentation before, during, or after the public hearing. We got very minimal information. I, like many others that were there that night, came just out of curiosity, just because we were wondering what is PLDC and what could it possibly do to our county. I was really interested in finding out more about the structure of PLDC, its intentions, its plan, and how its authority would affect public lands and our community's everyday life. I left that night disappointed, frustrated, and deeply disturbed. Disappointed that the public was not a participant in any authentic, well-intended manner, frustrated at the shallow attempt to keep the public involved, and very disturbed by the obvious one-way process. The massive turnouts at the public hearings held on the Big Island, Kauai, Maui, Molokai, and Oahu should have been enough to demonstrate that follow-up hearings should and must return to the neighbor islands. I cannot begin to express the anger of our communities at being left out of direct dialogue with the PLDC through a hearing such as this. Instead, we are told to email, write, mail, fax, or buy a plane ticket to Honolulu to participate. We took time that night, time out of a busy life, away from work, family, our activities, to attend, out of fairness, to listen, because it was that important to us. We were told we would continue to be included and that our input was valuable, yet the next time we heard from the PLDC was to find out that instead of returning as expected, the kuleana was on us to come to you if we wanted to participate. Once again, taking time off from work, family, and other activities. Only this time, we paid airfare to come. We used airlines mileage, points intended for family vacations, not to come here to protect our public lands. We are expected to trust a new agency that seems to be unable or unwilling to comprehend the level of value the public places on genuine, good faith community engagement. We are expected to accept decisions that will impact our public lands for decades, long past an administration or two or three. We are expected to tolerate agreements and contracts made outside of competitive bidding that could affect any of Hawaii's 67 state parks, 20 boat harbors, and approximately 600 miles of public access trails. Having said all that, relative to these draft administrative rules, I do want to point out the following, and I will likely go over the 3 minutes, and I hope you grant that since I flew here from Maui. On page 30226, item 7, it talks about community groups having a summary of comments completed and included in preliminary approval. Why is this optional and not a requirement? And why is it a summary? Page 30226, item 8, there's a description of how land planning activities for the project will be coordinated with the county planning departments, but this description should be specific. Is this coordination a telephone call, a meeting, an email? What are the ramifications? Avoid vagueness. In 302-35, item E, the final project proposal says that it shall contain all of the conditions or restrictions, and this is your word, suggested by the county. Why is it not a requirement, and what are the ramifications if these conditions are not met? On page 302-33, item A, It says, quote, an eligible project applicant or project partner shall conduct or participate in at least one public meeting in the county, community, or development plan area to solicit community input on a proposed project. This public meeting shall take place prior to final determination. Why only one? I saw a graph, and you folks have developed a very nice flow chart with lots of, there we go, lots of nice-looking public meeting icons, but yet I couldn't find a correlation of the 4 points where it talks about public meetings. I only found one that was required. So the picture says this, but the text says something else. So again, I'm unclear, and since there can be no questions asked today, I guess that one might not be answered. Additionally, Maui County works hard at creating its own community plans and uses an incredible amount of time that's put in by our own planning commissioners, general plan citizen advisory group members, so we can achieve smart growth. Future development ought to be county-driven and not state-imposed, bypassing local zoning laws put in place by the people of that place should remain a requirement to follow. The way the PLDC arrived at our doorsteps, passing through the House, Senate, and signed into law in an unheard of 3 days, the weak effort it makes to work in partnership with the public, the lump sum characterization of critics as hysterical, drum-banging troublemakers, the use of monies intended for land conservation to pay for PLDC salaries for an agency tasked with commercialization initiatives and not conservation efforts, well, it's no wonder that so many of us believe that a rewrite of the administrative rules is not the answer. It's not a rewrite, it's a repeal. So far, the PLDC has heard that some folks want to give it a chance. I would say that the PLDC has had many a chance to meaningfully communicate with the public and earn our trust before it gets full authority to work with our trust. A tremendous amount of people across our islands in Hawaii are at odds with the PLDC, and rather than spending months wrestling with pages and pages and pages of rewritten, reworked administrative rules, vilifying each other, generating negativity in our own communities and government, I honestly think we just need to stop where we are, call it a day, and I'll wrap up, and maybe even a new day in Hawaii where widespread public disapproval in the state will be respected. Finally, when the PLDC came to Maui, we looked for a genuine, sincere partnership. We asked to be kept involved in the loop. We asked that our questions would be answered. We asked that you make this pono, not poho. We asked on Maui that least of all, you not have public hearings just so you can meet a check mark on your list of things to do. We are neighbor islands, not outer islands. There is no state of Honolulu. Neighbor islands should rank just as important as Oahu. Come back. If you continue, you may hear the same message anyway. And again, I ask you to think about not rewriting it, but repealing it. Mahalo.
Raymond Lowe, and then after Raymond, Kat.
Hello. Aloha. My name is Raymond Lowe. I'm just a surfer down Kewalo Basin. I'll tell you what I think of this PCLD guys. I had dealt with HCDL guys. They're Honolulu, and it seems like they're doing the same. You guys are just the same situation, but on a statewide basis instead of just in Honolulu. And I think that's not fair, because I've seen what happens already at Kewalo Basin. You just let a problem go until it gets so bad, so we say, oh, well, let's privatize it. We see that happen at Kewalo Basin. What they're doing now is it's privatized. You can't even put your fishing pole in the line without a guy coming in and telling you, hey, you're not supposed to be here. We've been here since we were kids. We used to do things like that. And you guys made it privatized, okay? There was a surf contest. During the surf contest, we had to tell the people to move their cars, the parents to move their cars, because the sheriff's going to give you a ticket. Sheriffs came to get a ticket. 20 minutes later, the sheriff left. Other parents that came from the next heat dropped off their kids and parked their cars. They got tickets from a person that says he can give you a ticket. Can find out he's a private person, and it says send the money to a P.O. box. Now, is that publicly, legally, you say, hey, this guy is now in charge of Kewalo Basin? That's what I'm seeing now. You guys have 20 years of problems, and all of a sudden you guys are the magic bullet. I don't see it happening. You had 20 years of kicking the thing down the can. Take a couple of minutes, just relax and figure out what you guys are really doing here. I see something here that's really wrong. And I think you folks look in the mirror, you guys know it too. It really hurts me to be here. I should be doing my work what I'm supposed to be doing, but I really feel strongly about this thing. I've seen HDA and Honolulu do this to Kewalo Basin. We try to stop, the public development of lands, which you folks are trying to do again. There is development, yes. We don't mind. Hey, it's going to come down the road, but smart growth like this, got to be smart about this and listen to the people. That's what I really wanted to say. But like I say, here you go. Look at these parks. You folks want us to go to the park. Milikahana, do you have a lifeguard? You want me to go swim, but you want to see a nice bathroom. Hey, when you go camping, just imagine what kind of bath you should get. You know what I mean? It's better than a hole in the ground. But I'm trying to tell you folks want parks, but you guys don't even protect what you guys have now. Take your family to Milikahana Beach Park. You want to have fun? Stay on the grass, stay on the sand. Put them in the water, they can drown. I already pulled in 2 people every year. I go there and surf. Low tide, they walk to that island. High tide, they try to come back, and it's 2 currents coming around. They're looking at me. I said, oh, there was a lifeguard here before. None of your state parks have lifeguards. And why? You folks telling us that this is going to have a lifeguard, you're going to have security. I don't believe you folks. It's just, it seems like a lie to me, but you folks should really listen to the people here in this public. And this development is not right. There is smart development. This is not the answer. Thank you.
Aloha, board members. I'm Kat Brady, testifying on behalf of Community Alliance on Prisons. I'm a justice advocate. This is really about justice. It's about justice for the people of Hawaii. Again, we express our indignation at the new revised rules, which basically your proposal is to limit public testimony. We've spoken to many attorneys who are land use experts, and all of them, and some of the attorneys have even served in the Attorney General's office and represented DLNR in the past. And they said to me, how did this law pass? How could such a law pass? No matter what rules you make, the laws trump it. So this is very scary to us because the wolves are salivating at the door. Oh, look at all those resources in Hawaii, and this is really interesting. We could make a lot of money. The public is really aware of what's happening. They're aware of the fact that you're putting up, oh, we're going to fix your parks, we're going to, do things that are for the public benefit. They know that there's something behind that because all of these things could be done currently under the statutes that we have. So we know that there's some unseen thing happening, and the public is kept out of the loop. Interestingly, that the executive director talked about pono. And the definition of pono is goodness, morality, moral qualities, correct or proper procedure, excellence, well-being, prosperity, welfare, duty, moral fitting, proper, right, just, fair, successful, should, ought, must, necessary. Unfortunately, the PLDC has exhibited none of these qualities. So your rules are kind of like rearranging the deck chairs on the Titanic. And believe me, your ship is floundering in the rising tide of public outrage. The only thing that we can suggest is this law has to be repealed, and we need to start over and have a full-on public process. Mahalo.
Aloha, my name is Carlos Dutro. I've been on Kauai Community Radio for 15 years, and it's very easy to talk. It's very scary to get up and talk in public. I flew over with friends from Kauai because I felt this was crucial. I'm surprised because our tiny little radio station studio room is bigger than this room. And how can you have such sweeping changes to the way business is done in the state of Hawaii with limited seating? I'm also amazed and take note that only 2 board members showed up, and I kind of paraphrase, because we could show up with only 2. How could they not show up? This is such sweeping change. Next, with all due respect to Kanaka Maoli, because the Hawaiian issue is going to be forever there until we untangle it, we have this thing called the state constitution. Article 1, Section 21, the power of the state to act in the general welfare shall never be impaired by the making of any irrevocable grant of special privileges or immunities. It's a state constitution. I don't know how that was missed. I'm concerned about a group of 5 people that will have the ability to bypass the political process and the ability to bypass county zoning requirements and possibly even bypass EIS procedures. Those are there for a place. How will these people be vetted? How will we be assured there's no conflicts of interest? How will we be assured that there's no favoritism, cronyism, etc.? From what I understand, you can make decisions with as little as 3 people of the 5 people present. This is government-controlled capitalism, which eventually leads to fascism. I'm concerned when I hear crown or ceded lands, which are Kanaka Maoli lands, redefined to public lands and finally just land. I think that's very dishonoring. I've heard before today the PLDC will be Oahu-centric, and I agree. Coming from Kauai, it's very hard. It cost me about $500 to get over here, get a hotel room, get a flight, take time off from work. This is going to disadvantage the outer islands. I'm wondering, where is the oversight? You have appointees and then you have division heads. Where's the oversight going to come from? This is such powerful, sweeping changes. I can't believe this is like a Saturday Night Live to have this in this tiny room with limited seating. Everyone in the state should be allowed to speak until time's up. I'm almost finished, and it will be less than a minute. I'm wondering, why the rush? I've been a talk show host for 15 years. I'm very fair. I bring Republicans, conservatives, liberals, Democrats, atheists, religious people. I get out of the way. I have not run across a single person in favor of this, not one. In Kauai, I was shocked at how few people know about this, but coming to Oahu, I spent a week here doing business for my work. I asked everyone I went in every hotel, shopping center, bank, mall. Nobody even knows that their life is going to change. I think this issue is going to unite all the citizens of this state. I think it's going to leave a stain on the politicians and bureaucrats that support and fight for this. And finally, it reminds me of selling a kidney to pay for your hospital bill. It's absurd. Thank you. I think I'm going to move outside if somebody outside wants to come in and take my seat.
And Martha Townsend.
That's me. Aloha, board. My name's Scott Majaris, and like Carlos Detro, the previous speaker, I also flew over from Kauai at the encouragement of many friends and family there. Unfortunately, they couldn't take the time or have the resources to come over here. We had a big meeting on Kauai, I think several hundred people, a couple hundred at least, at the elementary school. Mr. Hariguchi, I think you remember that. You were there. I'd like to just, I was so moved by Mahina Martin from Maui. Her testimony pretty much said everything that I would have liked to say. So if you wanted to include my name for the record on her testimony, I think it sums it up. But in addition to that, I just want to make sure that everybody listening knows that the County of Kauai, our county council, unanimously voted to repeal this act. I think they did so from public pressure. And I also, at our initial meeting, one of the last speakers was Gary Hoosier, and he's an appointee of the governor. He stood up and spoke with his displeasure of what this act, what impact it would have on the citizens of Kauai, and how he felt the EIS system just wasn't even, if it was even been used, it has no teeth in it. It wouldn't protect the people from development. I'd just like to say also that I have this really uneasy feeling that we have a system of laws, especially in Hawaii, that were put in place over a long period of years that were set up to protect our resources. And it seems like this act, it acts to circumvent all of those laws and expedite this development. And the real problem, I think, is that our government is broken. Our government has failed to take the taxes that we work hard to pay and use them in a way to maintain our resources. And I don't know where the money's going, but I don't know that this is going to fix it, because if we sell our lands and offer them out, what's going to happen when we have no land left to sell? We're going to be in the same spot. So something has to change that way. And before I leave, I would like to compliment Mr. Aila. I've been watching you. I can see that you're very engaged in the testimony, and I appreciate that. All of the board members, but Mr. Aila especially, and I really do appreciate your attention. It looks very sincere, and I hope that this testimony is touching your heart and giving you some thought. And that's it. Thank you. Aloha.
Aloha, my name is Martha Townsend, Executive Director of the Outdoor Circle, testifying in opposition to the PLDC as a statute and the rules as proposed. Land use laws, zoning requirements, environmental protections, these were all developed over years and years to prevent past poor decision making, such as locating incompatible land uses next to each other, like landfills next to schools, or jeopardizing our natural resources, like allowing stormwater runoff into our streams. Nothing should be exempted from these protections. They were developed over time, having recognized past mistakes and attempting to prevent them in the future. Exempting projects from these time-tested protections is foolish. Good planning is not a burden. It is a requirement. Good public engagement is not a burden, it's a requirement. The changes made to the rules as proposed do not address many of the public concerns that have been raised throughout this entire process, from the time that the public became aware of the statute now on the books to today. And many of us recall the PLDC, in discussions about the PLDC, that our public concerns would be addressed during the rulemaking process. And here we are in the rulemaking process, and that's not the case. I'd like to highlight the testimony of other people who have mentioned that you actually don't need the PLDC to do any of the projects that have so far been proposed. Caring for our harbors, maintaining parking lots, cleaning toilets, those kinds of things don't require special exemptions. We can fulfill the obligations of government without doing unnecessary exemptions from laws meant to protect the public's best interests. And for these reasons, the Outdoor Circle and many of the people here urge you to not adopt these rules and are actually going to advocate for the repeal of the PLDC. Thank you.
Lisa? Yeah. And then Frederick Bird.
Okay. Hi, I'm Lisa Grandinetti. I'm a senior at Mililani High School, and I'm here to object to the administrative rules and Act 55 itself. Living in Mililani, it's easy to understand the benefits and detriments of development being in the middle of it. As one of the first master planned communities in Hawaii, Mililani set the example for a somewhat more responsible mode of development. but the extent to which development has expanded is both unrealistic and unsustainable. This is the point that it is necessary to level off the development of our islands and shift to a mode of thinking where solutions can be made for the problems of existing development. Despite this dire and obvious need, we are doing precisely the opposite. This bill, as you know, gives the PLDC the access to virtually any land it pleases. The possibility that this power will be used to expand agriculture, a more favorable option, is unlikely, and the implications of this bill are inescapable. One consequence that hits close to home is the Coal Ridge project. After decades of justified and logical resistance by the public, Coal Ridge, just one of countless anti-agricultural development plans, will be effortlessly approved with the passing of this bill. Coal Ridge will create an entire community of thousands of homes that Central Oahu is just not equipped for. All surrounding areas, including Mililani, will be forced to endure the effects of this development. This is a story that people all around the islands share, and we have come together to save our future. If this bill is passed, it will result in a lifetime of recovery efforts on the part of my generation. Although I would be completely willing to do this, I'd rather focus my efforts on a more positive rather than reactive movement. Save us from this terrible fate. Let us dedicate our lives to bettering our lands instead of restoring them from the results of this bill. Please vote to repeal Act 55. Thank you.
And then Peter Lee.
Thank you, board members, for the opportunity to testify today. My name is Frederick Berg. I'm testifying on my own behalf. I would like to say that I've worked for the Department of Hawaiian Homelands as well as private developers. So I've sat on both sides of the fence. And just the only thing I want to say is that public and private partnerships are very valuable to the state. It's worked for many, many years. And I would encourage all of us to get together to make sure that this can work positively for everybody involved. Thank you.
Good morning, Mr. Hariguchi and members of the board. My name is Peter Lee. I'm with Hawaii LESIT. Hawaii LESIT stands for the Hawaii Laborers, Employers, Cooperation and Education Trust. We are a labor management partnership between the Laborers Union of North America, Local 368, and its 250 signatory contractors. We commend PLDC with clarifying the applicability of certain statutes that concerns all of us, particularly Chapter 343, the EIS law, Chapter 6E, Historic Preservation, Chapter 92, Sunshine Law, Chapter 104, Wage and Hour on construction projects, Chapter 171-64.7, Restriction of Sale of Ceded Lands, and finally, Chapter 444, Contractors Licensing Law. We support these proposed draft admin rules and PLDC's effort to better utilize state resources, create much needed income for the state, and promote economic development. Mahalo for the opportunity to provide testimony.
Kyle Yamada, and then Colleen McNeil.
Don't know. All right. Good morning. I'm Kyle Yamada. I'm a senior at Mililani High School. I'm supposed to be at school today, but I came down to offer my testimony. And on the administrative rules, I believe that it is in direct violation of the procedural due process. What really scares me about the PLDC is the partnerships it aims to create. If we look beyond the PLDC's exemption from the zoning and developing laws that the people and the government has to abide by, when a public-private partnership is forged, what then happens? Even more exemption and the subsequent appropriation of the rights that the people of Hawaii were meant to enjoy would go to private corporations and their enablers. This would then create direct encroachment on the right to property and the right to any mediation process. So every time I go up to the North Shore of Oahu, I'm in the car and I'm on Kam Highway. I look out the window yearning for a view of the ocean. Instead, I just look at houses, and every 200 meters or so, I finally catch that quick glimpse. And those few seconds of what should be joy, I'm just reminded of a steep miscalculation of an externality. The developers of these houses cut off the connection with nature that we all want to see. And the houses they build destroy the ecosystems of the coastline. The PLDC supposedly has to comply with these environmental and federal regulations. Regardless, they hand over the Hawaiian land to non-local private corporations who are proven and perennial violators of these regulations. This encroachment of private corporations on Hawaiian land and communities is an inherent flaw to which rewriting the laws wouldn't be a solution, and the only thing that I can think of is the repeal of the PLDC. Thanks.
And then Dana, Kauai.
Good morning, Chair Hariguchi. I'm Mr. Aila, members and staff of the PLDC, and Joy, who just left. My name is Pauline McNeil, a resident of Hawaii for 30 years. Excuse me. Perhaps if the public had more opportunity to provide testimony on SB 1555, the legislation that led to Act 55 and the creation of the PLDC, we would not be here today recommending changes to the rules, hoping to prevent the haphazard and potentially destructive development of our limited public lands. Our greatest need at this stage is transparency and accountability in the rulemaking process. For transparency, we will need, first, internet access to your records and procedures. 2, each development to be identified by name on the PLDC website with information on the stage it is at in the flowchart process. 3, email notification to elected representatives, neighborhood boards, community associations, community groups, and interested individuals prior to the board adopting, amending, or repealing any rules. 4, a monthly public notification of the state properties under consideration by the PLDC given to the neighborhood board and other community organizations in the area where the proposed land development is located. 5, all documents filed with or presented to the corporation to be retained in the files of the corporation. For accountability, we will need, number 1, the reintroduction of procedures to allow the public to add an item to the board's agenda. This was deleted in the last revision of the rules. 2, an increase in the representation on your board. I recommend the addition of 6 new members having agricultural, environmental, and cultural backgrounds to assist in evaluating how a proposed project would fulfill the purposes you have stated, quote, to use public lands for the economic, environmental, and social benefit of the people of Hawaii. 3, at least one public hearing to be held in the community where the project is located, and this meeting should be held in the early stages of the negotiation process. And last, 4, a second public meeting in the community if the time for testimony runs out at the first, to ensure that our elected representatives and government employees have the opportunity to hear what the public thinks about the decisions the PLDC is making on our behalf. These recommendations are secondary to the necessary repeal of Act 55. Mahalo. Yes, I sent one. Yes, I did.
Lena, Kauai. And then Josh.
I'm Lena Tamai. I'm a junior at Milani High School. First, I'd like to say that me and the two other high schoolers that were in here, we're actually missing school to come and testify because that's how much our opinions we feel should be heard. And we're here to oppose the administrative rules. I'm not of Hawaiian descent, and I cannot say that I am, but I was born and raised here in Hawaii, and I grew up with this rich culture that can only be expressed and seen here. And this place is about, to me, this place is about family and connections. And one of the connections that PLDC I feel violates is a connection between the land and the people. I feel that the land is something that we share, especially public land, because everybody is allowed access to it. And PLDC takes away our voice when it comes to public land. We don't know what you guys plan to do. We don't know what's going to go on. So we're not allowed to express our opinions and views on it. And I feel that that's not right because, in a way, it's partly our land. It's our right to be able to say how we feel about it. Another thing about this Act 55 is that it, in a way, may alienate Hawaii because there's nowhere in the language of the Act that specifies what exactly can be done with this law. I know some people say it can be used for agriculture, but there's nowhere in the language that specifies that. And it scares me that this can be taken advantage of. Other things can be done with the land. And my generation and everyone after me are the people that are going to have to deal with these consequences. We're going to have to live with the changes that are made to the public lands. And we're going to have to live with the fact that we have lost our voice upon this act. We lose our voice and our say in government because we don't get to say what's happening to the land that you're taking away from us. It saddens me that this is actually up for debate, the fact that we're going to lose our voice, because things can be made that we don't want happening. Things like our land getting taken away. And I have a little brother who loves going to public parks, public beaches, and the chance that these places can be taken away from him, it scared me. Because in the future, they're not even gonna know what it's like to go to these places. Thank you.
Then James McCulley.
I want to know where it is. Aloha mai, Executive Director and board members. The Office of Hawaiian Affairs appreciates this opportunity to testify on the revised proposed draft rules. My name is Jocelyn Doan, and in addition to being a Mililani High School graduate, I'm a senior public policy advocate at OHA. As everybody in this room likely knows, OHA is the constitutionally established body responsible for protecting and promoting the rights of Native Hawaiians, and we have substantive obligations to protect the cultural and natural resources for our beneficiaries. As a part of our broad kuleana, we're required to serve as the principal public state agency for monitoring the activities by other agencies, that impact our beneficiaries, as well as advocate on behalf of our beneficiaries. So upon learning about Act 55, we endeavored to understand its legal implications and hired counsel and consulted with other attorneys that are experts in Native Hawaiian law. These attorneys have extensive experience in litigation and public policy making on Hawaiian issues, particularly Native Hawaiian traditional and customary rights, and helped us to form the foundation of the recommendations we've made both legislatively and before you today. OHA recognizes that with appropriate protections in place, that the PLDC has the potential to facilitate the revenue that the DLNR so desperately needs. We understand that the DLNR is the state agency with primary responsibility over the land and resources that are very important and critical aspects to our beneficiaries' lives. So understanding such, in April, May, October, September and October of this year, we submitted in writing specific amendments to the rules. You have our written testimony in front of you today, which includes the 3 formal letters, as well as today's the letter regarding today's hearing. Unfortunately, most of our suggestions were, and more importantly, our concerns have not been addressed in the current draft of the rules. OHA's suggestions are by no means the only way to address the concerns that we've raised, we've heard the public raise, and we've heard our beneficiaries raise. However, there's been little changes in the rules that would ensure transparency, due diligence, and accountability in PLDC projects, community input on proposals that are carried out by the PLDC, and provide minimum standard of information that the public will have so they can meaningfully participate, mandate consultation with applicable state, county, and federal agencies, including OHA, as well as local civic clubs, Hawaiian Homestead associations, equal and transparent planning for all projects, and culturally sensitive development projects. The aforementioned is a summary of our written comments, which I obviously won't read for you today. It's a little long, it'll take me longer than 3 minutes. So we just wanted to, and I'm going to try to be as fast as possible because I want to respect everybody in the room who's come to testify, as well as your time. So wanted to reiterate that the rules should reflect the PLDC's kuleana to public trust assets, Native Hawaiian traditional and customary rights, and the resources. And a memo that was recently issued by the Legislative Reference Bureau confirms our concerns over PLDC's exemptions and states that the projects are likely exempt from HRS 205, HRS 205A, as well as various county zoning. Failure to replace the planning tools embodied in the statutes could result in decisions that, amongst other things, adversely impact Native Hawaiian traditional and customary practices, degrade natural and cultural resources, and adversely impact historically significant sites. I'm going to very briefly focus our testimony on suggestions to assist the PLDC in fulfilling its statutory obligations to develop an appropriate and culturally sensitive land development program, and mandate that the PLDC consult with all appropriate county, state, and federal agencies. Unfortunately, there continues to be little in the rules that assure cultural sensitivity to the unique challenges that our beneficiaries face. Amongst other things, we believe and reiterate that the guidelines for PLDC projects should ensure that there's no interference with traditional and customary practices, that the environmental resources and cultural resources are not impacted, and that ensures consultation. While we believe that the PLDC's statutory responsibilities require that the corporation incorporate cultural considerations throughout the entire planning process, the definition of culturally sensitive is only referred in the administrative rules one time. And the remaining rules, and that's in section 23. The remaining rules fail to give cultural sensitivity its statutory authority and instead expressly allow projects that may not be culturally sensitive. If we look at section 22 of chapter 302, it describes an eligible project as one that helps preserve culture, agriculture, conservation, or preservation, which would allow projects to move forward that may not be culturally sensitive. And finally, OHA reiterates that the PLDC should mandate consultation with all applicable counties, county, state, and federal agencies. This is particularly important because of the PLDC's exemptions. The oversight agencies really, for Chapter 205 and 205A, for example, so state and county agencies, they have objective oversight, specialized expertise and experience, and when they grant permission, either through a permit or a boundary amendment, for example, they do it on a case-by-case basis after making specific findings. So while these agencies have this particular kuleana and expertise, you know, if the projects are exempt from those laws, the rules don't replace them with anything else, then we think that's concerning. So again, in conclusion, OHA urges the PLDC to adopt OHA's suggested amendments or as always, we've been open to sitting down together and working on how the rules can ensure respect and protection for Native Hawaiian culture. Mahalo.
James and then Tish.
Chair Hariguchi, Chairman Aila, hello. My name is James McCulley. I've traveled here today from Hilo. I'm representing myself. I'm a member of the Kanoilehu Industrial Area Association as well, and I'm in discussions with the other lessees in the Hilo industrial area. And I'm here to support the adoption of the rules. It seems there will be a vigorous and extensive debate with regarding PLDC, and the lessees in Hilo consider the PLDC to be an evolution of Hawaii's significant and extensive land use laws going back to the 60s in the Land Use Commission. With a state that has 40% ownership of all the lands, there's always going to be concerns with how the lands are used. In our instance, we're talking about highly developed industrial properties and resort properties in Hilo. Anybody who has visited Hilo knows that the current industrial plant is dilapidated, and it has to do with the nature of leasehold and the inability of the lessees to improve what amounts to wasting assets. To the PLDC's board's awareness, this map here was developed in conjunction with the County of Hawaii, and the orange and brown colors reflect state ownership of industrial properties in Hilo. About 91% of all industrial lands in Hilo are owned by the state of Hawaii. So it's a significant, and the Banyan Drive is 100%, which is our resort area. So it's very important that the state have some flexibility in how to approach the utility of these leases. This is the muscle and the bone of Hilo's small business. If we are going to have an attractive face, which is tourism and Banyan Drive, Hilo needs help. We're a sick entity right now, and our economy is suffering due to the failure of our industrial base and our resort areas. The state DLNR has a list of income-producing properties. 87% of them are in Hilo. There are over 918 parcels of land between the Hilo Wharf and Panaeva, where the agricultural lands begin. This is a very difficult group of parcels to manage. DLNR has many responsibilities, and land redevelopment and land planning is a very significant specialty that is very difficult to assume. And this is the first time it has to be done. Most of these leases began after the 1960 tsunami. We're reaching the end of the statutory period for these leases. So it's very important that the government be aware of how this land tenure system is affecting Hilo. In the preamble to SB 1555, which became the PLDC, the focus was also on the optimization of state lands. So regardless of what occurs with the discussions regarding the PLDC as it was formed, I'd like to recommend that the board and all the legislatures that attend to this issue consider the Public Land Redevelopment Corporation as the primary focus in the beginning of this process. Let's make use of our underutilized wasting assets, such as the Hilo Industrial Area and Banyan Drive. It's very important that we become more efficient in our use of already developed urban properties. Thank you very much.
Thank you, Chair, Director, and members of the board. My name is Tish Warhara. I am in support of the establishment of administrative rules for the Public Lands Development Corporation. My career has included both public and private sector experience, including serving as the Director of the Office of Environmental Quality Control and as Deputy Director for the Department of Agriculture. I'm currently serving as the Director of Marketing for Armstrong Produce, a wholesale produce company. The creation of such an agency as PLDC by the legislature speaks to the need for a much more simplified process of approving and moving public programs and projects forward. I recognize that the majority of testimony here focuses on the negative and presumed harm that could be done by such an agency, but I prefer to focus on the positive and the good that such an agency can accomplish. One of the great frustrations of being a public official is that of dealing with a very cumbersome, sometimes a very convoluted procurement process. The enormity of paperwork and protracted timelines do indeed make the wheels of government turn slowly, which may in turn cost government much more in the long run. I do not dispute that the expenditure of public lands and funds must be strictly scrutinized. Environmental and public reviews processes should not be compromised either. But I also feel that in troubled economic times, we must find creative ways of meeting important state goals. Sometimes the worst of times can bring out the best new solutions to tackle problems. And I think that through the PLDC, we can do some of those things. The Public Lands Development Corporation can enter into public and private partnerships, not only to expedite projects, but also in light of the state's current economic situation, to cost share. There have been several examples of such partnerships, and some of the previous speakers have addressed those, many with very good results, such as the fast tracking of building new schools on the west side of this island. Perhaps there are other, even more creative opportunities that should be explored. One problem that continues to plague this state is the entry and the establishment of invasive species. For years, there has been talk of the establishment of centralized inspection facilities at all the ports of entry to stem the tide of invasive species entering Hawaii and disrupting our fragile ecosystems and, in turn, our agricultural industry. For well over a decade, little has been done to move this agenda forward, in large part due to the economic downturn and lack of adequate funds. It is difficult to be able to conduct inspections properly without the proper tools or the facilities to do so, and we're going to continue to lose ground on this invasive species issues unless there is something done much more creatively. I believe that a public partnership could help alleviate waiting another decade or so for something to be done. The PLDC could explore proactive options and expedite the process of bringing partnering entities together for the good of the state. I firmly believe that the PLDC should be allowed to establish their rules, which will help to better define and set the parameters for its activities to allow important programs such as these to move forward. Thank you for the opportunity.
Senator. And then Chad.
Aloha, members of the Public Land Development Corporation Board and Executive Director and staff. My name is Laura Thielen. Still getting used to the senator portion. Former chair of the Department of Land and Natural Resources. Thank you for the opportunity to testify today. I've submitted some written testimony, but I guess I just want to touch on some points. A lot of people today are testifying in front of you about positive things that can be done. Jim McCulley was talking about the redevelopment of the Hilo industrial area and the Banyan Drive resort areas. You do not need an exemption from existing state land use laws or county zoning laws to redevelop those areas. They are already zoned and classified for urban and resort use. Dean Okimoto was talking about agricultural accessory facilities, value-added processing for agricultural operations. You do not need an exemption from county zoning or state land use laws to build those facilities on agricultural lands. They are authorized. Sheldon Zane was talking about the need to repair existing infrastructure, our roads, our bridges. You do not need an exemption from state land use laws or county zoning to prepare those facilities, nor do you need an exemption to enter into public-private partnerships for development. This board heard testimony from across the entire state, and one of the premier complaints that you were asked to address in your administrative rules was the fact that the Public Land Development Corporation is exempt from state, local land use laws and zoning. And that's the biggest fear that people have. If all you want to do is do the positive redevelopment that people have talked about today, or that is being pictured up there on the screen, all of that is allowed under the existing zoning, and you can follow those rules. And you had the opportunity to adopt rules that said that you would abide by these key land use and zoning laws, and you did not do so. In fact, the amendments that you made actually made it worse, because under your original draft rules, Section 13302-25, your original draft rules actually required all PLDC projects to follow existing laws, charter provisions, and rules, and be as consistent with the county, community, or development plans for the area as is practical. So your original draft rules did commit to following some of the local zoning laws and charter provisions relating to the county, community, and development plans. But in the amendments that are before you today, you took that language out. You struck the requirement to follow existing laws, charter provisions, and rules. So you eliminated even a shadow of a commitment to follow some type of zoning. Another complaint that was heard by you as you went around the state in your administrative rules is the fact that there is no meaningful opportunity for public input when the PLDC engages in significant decision makings about development. And I find it disappointing that even though you were fully aware about this complaint, that you chose to hold a single hearing today in Honolulu in the middle of the day before making a recommendation back to the board on the adoption of these rules. I think the board had the option to resolve a lot of the community concerns, and it did not address that in your rule amendments. And the board has demonstrated today in this hearing that it's more interested in expediency than in providing Hawaii residents with an opportunity for meaningful public input. And according to my interpretation of your actions today, this board has confirmed the need for the legislature to take up Act 55 again and either repeal it or significantly amend it, because we cannot rely on the board or the staff to adopt good governance processes. So thank you for your time.
Shannon and then Ms. Harris.
Good morning, board members, Executive Director Hariguchi. My name is Shannon Olivado on behalf of the General Contractors Association in support of Chapters 301 and 302 and the amendments set forth. Just like to take this opportunity to thank the board and the staff for another opportunity to share our support for the PLDC and for addressing the suggested comments from the first round of public hearings statewide. Particularly, GCA commends the board for further clarifying the definitions set forth in 302 and encouraging the use of sustainable green building practices. Furthermore, the rules, together with PLDC's strategic plan, confirm compliance with state environmental protection, historic preservation, sunshine law, wage and hour, ceded lands requirements, and licensing. Moreover, all PLDC projects will be required to meet strict federal regulation compliance, including but not limited to NEPA, Federal Endangered Species Act, National Historic Preservation Act, Federal Pollution Prevention Act. The list goes on, but those are just a few that I mentioned. With all due respect to the previous testifiers, this in no way belittles what they have to say here today. But I think the important part of this that we all have to remember is a bigger picture of economic opportunity. When we look at countries like Spain, Greece, what they're going through, ladies and gentlemen, I think it's really clear that we have to be looking towards opportunity and not knocking something that hasn't even presented its first project. It disheartens me to see young people, high school students here, saying that this is something that is going to be taking them or removing them from the process, when this process right here is something that they are participating in and will be able to participate in the future on. Senator Thielen spoke about projects that don't need the exemptions, that don't require PLDC in order to do them. But in reality, as people have spoken today, they have projects that they've been looking at, biomedical facilities for invasive species. These projects have been discussed over and over for years. Have they come to fruition? Not today. They probably won't come up tomorrow, and probably not in my lifetime, but they are possibilities. And I think that's what PLDC offers, especially in this economic times that we have today. And so GCA remains in full support of the PLDC and further working with it, whether the legislature looks at it again. But we're positive, and we want to remain positive and encourage the public to stay informed. Don't be misled by all the negative comments and everything that people are trying to downplay this organization as being. And with that, I thank you for this opportunity.
And then Kika.
Good morning, Executive Director, members of the Commission. I'd also like to thank the members of the public who came today. Obviously, coming during a workday is not easy, so thank you for the opportunity to engage in this administrative process with everybody who's here. When Act 55 was passed, concerns were raised thereafter, and there were promises made by a number of the key legislators in support of this bill who said, don't worry, the concerns about environmental protection, cultural resources, and public process will be taken care of through the administrative rules. So that's why we participated through the administrative rule process with a fairly high level of engagement. We submitted comments to you, Mr. Hariguchi, during the first draft. We submitted comments to you when it actually went out for circulation. We have taken the time to talk to some individual commissioners and suggest rules. And it's been frustrating in that, A, there hasn't been a lot of back and forth on that, and B, most of those proposals, which are relatively modest, they're taken from other laws that are designed to ensure that environmental resources are protected. It doesn't say you can't do projects. It simply says projects are going to have significant adverse impact, will not be allowed to go forward unless you mitigate it. And those revisions haven't been included. If anything, the rules are going the opposite direction. And it's obvious they're being written by somebody who wants to protect the Public Lands Commission's discretion to be able to approve projects. So if you want to approve a project that destroys 1,000 acres of ohia forest, you can. If you want to do a project that destroys a beach, you can. Build a hotel in areas that most people would say are pristine, shouldn't be, you can. And you're not trying to take those projects off the table, or at least say that we're going to try and mitigate those projects. So, through this process, with over 4 attempts to offer suggestions, revisions that haven't been taken up, unfortunately, this body itself is creating the fuel by which the public is saying that we should repeal this law. You're creating the fuel by which people have an opportunity to criticize this process, because really the administrative rules were supposed to be the area by which you're able to say, hey, certain environmental and certain cultural protections are being built in. And unfortunately, this draft does not do that. There is very palpable concern by the public. It's very real. And we have a lot of examples of bad government projects that have happened in the past. And so, when you say that we're giving an agency that's exempt from laws that have been created for after decades of experience, there's a reasonable basis for this concern. So, looking forward, looking at public access, making sure that public parks are available for certain community areas, so kids growing up will have parks. Making sure that beaches are protected, so much like DOT's project on Maui doesn't occur where we actually lose a beach forever and ever. Things like making sure that you guys have minimum standards for building codes. Making sure that the projects move forward aren't slum projects, and stating that in the rules. Long-term planning, making sure that we're really trying to do that, and simply saying that we'll let the community participate in the infrastructure conversations really isn't that long-term planning. And I guess I'd also like to point out that the strategic plan, which I think was a good step or a good effort to try to say, hey, we're going to try to recognize certain things, is not binding. It's not, it's not an obligation on you, and it's not an obligation on future Public Land Development Corporation commissioners. So you're making a promise to the public saying, hey, don't worry, we're not going to do this on important ag land, but there's really nothing binding there. And so in some ways, I'd say it's almost an abuse of the public's trust. Now, I don't say that individually of any of you. I say that as the broad statement. If you're going to go out in the public and say we're not going to do that, let's at least make it in the rules. Let's at least make sure that there is some commitment to that statement. Finally, again, I have to say these images are almost sort of insulting that are going up on here. I'm involved in some of the DLNR's projects to do public-private. We do those already, and some of them are great, some of them aren't, and a lot of times I think it really has to do with the resources DLNR has. And that's why I think the Sierra Club's been a strong supporter of trying to find alternative funding mechanisms for DLNR, making sure you have the resources to actually do these things adequately. So, to tell the public that we need it to protect the Iliahi or to look more like a national park, I think is really, it's not being candid, it's not being fair. And if that's really what you intended, I'd suggest revise the rules to say that these are the types of projects we'll do only. We're going to take off those destruction of pristine forests. We're going to take protection of beaches seriously, the Coastal Zone Management Act, et cetera, and then commit to that. And that's the way you build trust. That's the way you build the public support for these types of projects. Thank you for the opportunity to testify.
Good afternoon. My name is Kika Bukowski. I represent the Hawaii Building and Construction Trades Council. I'm here representing the organized labor in the construction industry. And I did submit written testimony. I'd like to stand on my written testimony and just offer a few brief comments, if I may. First of all, I just want to state that we respect and really are listening hard to some of the comments made by those who oppose the PLDC primarily, while recognizing this isn't the time and place to oppose the PLDC. This body did not create the PLDC. It was created in the legislature. So there's a time and place for everything. We're here to try to move forward and try to work within the rules and make it the best that we can moving forward. And we're very encouraged by what we've seen so far in our interaction with the PLDC. We've had concerns with the rules as they first came out in their first drafts. As an industry, as a coalition of organized labor in construction, it brings concern when we hear about circumventing building standards and building and zoning and whatnot. That hits to the core of our industry. So if anybody, and with all due respect to the Hawaiian cultural and Hawaiian concerns, the construction industry has a stake in this game as well from an industry standpoint. So we take it very seriously. We have been very encouraged with the response and the interaction we've had with PLDC in incorporating some of the amendments that we've proposed that addresses our concerns, and we continue to follow. The only thing I can suggest to those who haven't seemed to find the same kind of satisfaction is to stay engaged in the process. This is the process. Stay engaged, stay informed. Some of the comments that were made that I'd like to just kind of point on is that, yes, as it was stated, maybe some of these projects that we're looking at doesn't require some of these special exemptions. But what it does require that we lack is funding. And that's what the PLDC is partially intended to provide, that mechanism to provide creative financing through private-public partnerships. So we look at that as a positive. And again, we just ask that those who are not quite pleased with what they've seen so far, please stay engaged, and appreciate this opportunity to testify in support. Thank you.
Hello, we meet again. Chun James from Kahuku. I will submit a written testimony later when I get back. I just scribble all this. This is all scribble. Of course, I voiced unequivocal objection to the public land administrative rules 301, 302, and I'm not sure what happened to 303, but that itself is a problem as well. The bottom line is, you know and we know that you could plow through this whole process, that you could just sit stoically and just go through the process and check off the process, and in the very end, you can get what you want because you are the big government. There's no doubt about that. None of us have any doubts about that. But the bottom line is this how we want our government to be run? Is this how we're going to protect the future of Hawaii? Let me just point out a few points here. We continue to be very alarmed that the PLDC board insists on plowing this highly controversial plan on despite fierce public opposition. You would remember that there were unprecedented opposition throughout the whole islands against PLDC. And yet, at the end of that controversial tour circuit that you had throughout the islands, only 10% of the sweat and tears and energy that people put into it were really recognized. The rest, which we refer to as a lot of cultural concerns there, were all not included. Actually, and also again, I just want to quickly point that we again object to the PLC members' ties to big government and big business. This does not bode well for the public. As well, again, there is no Hawaiian or environmentalist or John Q. public appointed to this very, very elite board. And may I also add that it is very curious that out of our island of 1 million people, that Mr. Robert Bobby Bunda has to be in the Hawaii Authority for Rapid Transportation, the real heart, as well as this PLDC. It does not bode well for the public when one person can be afforded on two most powerful boards on this island. And again, we're very alarmed at the lack of information given to the public concerning the big picture, interrelated goals of PLDC and the Honolulu Rail Transit-oriented development. Tomorrow, there will be a meeting, and all these groups here really have very, very dangerous capabilities to condemn and to seize private property lands through eminent domain, and this is something that the public has not been able to connect the dots together. But I would encourage the public to look at the TOT documents, and in the July minutes of this year, you will see the interaction of PLDC and TOT, as well as other big developments. In fact, tomorrow there's going to be a meeting where HART is going to discuss whether they would want to create a council of developers. And again, you are playing semantic rules. This is so much a exercise of semantic gamesmanship. A developer is no longer a developer in the rules. A developer is now called a project planner. And again, we submit to you that creating a fiefdom such as PLDC is not an answer to good governance. We do not need another layer of bureaucracy. especially one that would be above the laws and controlled by a few appointed elite cronies of big government and big business. The way to lean and efficient government is to discipline its spending and tighten its management and priorities. Whether in lean times or in good times, big government has got to rein in its spending, or there will never be enough money for the government to spend. Again, in the public interest, we submit that the Department of Land and Natural Resources must remain the entity to manage the public assets and resources. Instead of siphoning funds and resources from DNR, the governor should seek ways to support and strengthen DLNR in its kuleana to protect, conserve, and manage Hawaii's precious and finite resources. PLDC, and TOT for that matter, is not about making Hawaii's lands better for people, invoking motherhood and apple pie lures of improving public schools and parks and harbors and workforce housing and so forth does not work with us anymore. We are no longer gullible. And we are Hawaii. We're not Russia. We're not China. And the governor had asked us to paddle our island canoe. But to us, we are expected to paddle in the island canoe, but PLDC wants to be the luxury cruise liner with reservations to owning a few elite groups. PLDC is detrimental to Hawaii's finite and precious resources. We cannot allow short-term desires for perceived, and I say perceived, profits to squash the birthright of Hawaii's future generations. The irreparable damage cannot be corrected. Please do not plow on. PLDC must be abolished through appeal of Act 55. Thank you.
All right, thank you. My name is Ben Sadowski, and I'm with Unite Here Local 5. After the last round of public hearings on the PLDC, the organization was supposed to refine its administrative rules based on public comments. It is now clear that the voices of Hawaii's citizens have not been heard, and that the PLDC has no intention of listening to us. That's why we're advocating for a repeal of the law. And maybe that's why this hearing is at 10:30 in the morning in the middle of the week. Previously, Local 5 testified regarding the need for labor peace provisions, which would protect the state's investment in lodging-related projects. But this has not found its way into the rules. Nor has the PLDC agreed to put restrictions in its own rules against developing agricultural land, despite what the strategic plan states. More than that, there are too many significant loopholes throughout these administrative rules, which could diminish still further the public's already reduced and often ignored input into the future of our state. For instance, in the revised rules, projects no longer have to generate revenue as long as they're self-sustaining. The original, albeit flawed, stated purpose of this bill was for the PLDC to be a way for the state to generate revenue. Under the revised regulation, it can develop our public land without even doing that. This violates the statute, and therefore, the proposed regulation will be invalid if adopted. Two of the early steps of the revised development process are the project application and an initial project proposal. Both of these could be written by the PLDC, which will then decide whether to approve the project. It seems unlikely that the PLDC would reject its own project, even if the public is against it. The PLDC's recent actions have proven that. In fact, the PLDC administrator can decide to waive the initial proposal entirely, which is very problematic. It's possible that the title agency, the owner of whatever land the PLDC wants to develop, could listen to the public and refuse to transfer the land unless the PLDC buys the land itself, which it will very soon have a budget to do. And then there will be no title agency and thus no public input there. We've been told that the county can impose conditions on the projects, but by these rules, those can only be related to infrastructure. And their ability to do that comes after the initial project proposal, assuming that the administrator requires one, which he or she may not. It's unclear when or even how the county or anyone else could meaningfully weigh in if this is waived. And then there's the final project proposal. The administrator can waive all sorts of conditions there too, including the final EIS, the status of compliance with HRS 6E, and the development schedule, among other things. I could go on, but I'll leave you with one final point. In the initial draft of the rules, PLDC was required to make optimal use of public land for the economic, environmental, or social benefit of the people of Hawaii. Now, all a project has to do is help a department or agency achieve its goals, which are undefined. In summary, these rules show exactly why the PLDC is bad for Hawaii and why it should be repealed. Short of that, we would need to significantly amend the law before the public can truly be assured that our voices will be heard in any discussion about the future of our state. I pointed out here just a few of the aspects of the revised rules which are very troubling, and these come even after all of the public comment on the initial proposed rules. But ultimately, we feel like this continues to be too problematic and that it should be repealed. But thank you very much.
Mr. Hooser, and then Laulangi Teal.
Good afternoon, Director and members. My name is Gary Hooser. I'm the Director for the Office of Environmental Quality Control, presently on leave, and I've been in that position for almost 2 years dealing with Chapter 343 environmental impact statement laws. I'm also a council member-elect from the County of Kauai and former state senator representing Kauai and Niihau for 8 years. I'm speaking today as an individual on my own behalf, not on behalf of the council or the Office of Environmental Quality or anyone else. My first question, first concern has to do with the hearings. As a neighbor islander, like many people here, I had to spend, $250 to come here and get my 3 minutes. And I'm very disturbed about that and wanted to know why the PLDC has chosen not to have hearings on the neighbor islands. Is it a budget issue? Is it a policy issue? Do you believe that enough input here, you don't need the neighbor islands? I mean, that's a third of the state's population has been basically left out of the process. Do you have a response?
You can submit your questions and I'll respond to you after.
Okay. I would like very much to know that. It's my understanding that over 80%, possibly as much as 90% of the land that potentially impacted by the PLDC is located on the neighbor islands. A previous young woman spoke very eloquently about losing a voice, not having a voice in this process. And I would say today is proof that a good third of the state has no voice today. In fact, the very creation of the PLDC through Senate Bill 1555, there was no opportunity whatsoever for the public to testify on the substance of the bill that created the PLDC. The public has had no voice, and it's no wonder that people are angry and that people want to talk on the substance of the issue. The PLDC allows projects to bypass general plans. Again, communities like Kauai, those general plans are updated every 10 years. There's numerous community meetings where people have a voice and they come out and they express their voice on where they want planning, where they want development, where they don't want development. And the PLDC allows all of that, all those voices to be ignored. I support a full repeal of the PLDC in Act 55, but I do have some suggestions for the rules as well. The PLDC takes away county home rule. The PLDC grants extraordinary powers to its development partners. It exempts projects from county plans, county zoning, and county land use laws. It gives all this power and control to 3 appointees, 3 of 5, appointees by the governor, at-will appointees. And so one question I have is when the 3 governor's appointees who are there as a result of the election of the governor are gone with the election of a new governor, what is their plans and the rules or otherwise for a transition when you have 3 people immediately leave their positions of a 5-member board? Secondly, I see no provisions for mitigation to environmental impacts in the rules. A lot of talk is about, well, 343 still applies, 343 still applies. 343, Chapter 343 is simply a disclosure document. Chapter 343 discloses environmental impacts, but there's no requirement, from what I can tell under these rules and under the law, that there any mitigation whatsoever is required on these development projects. Those mitigation requirements should be at the minimum included in the rules. Also, there's a lot of talk about coordinating and consulting with the counties on PLDC projects. I see nothing in the rules that specifies whether that consultation and coordination is with the mayor, with the council, of which I will be sitting, with the planning commission, or with agencies within the county. During the normal process, the council often has a say over land use issues. Certainly the planning commission has a say, and the mayor and the agencies obviously have a say. But it's not clear, it just says coordinate and consult. You know, there's many, many items that I'm very, very troubled by the creation of this. Again, during the legislative process, there was no opportunity, and the public record is really clear. There's no opportunity for the public to testify on the substance of the creation of PLDC. And I'm concerned that the hearings are not being held on the neighbor islands. I'm concerned and share my dissatisfaction with the messages being projected on the board, the fact that this meeting is held in a room that is far too limiting at a time. I mean, there's a lot of people outside there. For these reasons and many other, again, I encourage you to look strongly at the rules and make it clear that I support a full repeal. Thank you very much.
And after that, now, Kulihi.
Joey, brother.
Yeah. Are you count?
Yeah. Okay. The first thing is I'll let you some water.
Okay.
Sorry. My name's Kelvin Hulihe. I'm just trying to change my life and show aloha and present my help, my aloha help. If you guys can give the information to the kapunas that kind of kapunas that watching the kids because that's the future. That's the future for the land and the kapunas. So the first people that gotta get the information, all these kind of things that's happening in Hawaii, is the kapunas that watching the kids, the kikis. It's the future for the future. So I'm just offering my aloha help. I get my number over here. You let me. Kapunas like that. They gotta learn that. They gotta get the information first. Only things they in the bedroom that the two guys they keep themselves secret. But anything happening else in Hawaii, they gotta know, brother. Okay. So I'm just here to show my aloha help and because but. Gonna come out, this kind of stuff all illegal. But he should read his petition because he's born here and present them to the United Nations and let the international community make a vote, make the judgment for what is right and wrong of whoever house we living in. Because when you go out of people's house, brother, you respect them, have consideration. What they say, if it's all right, nothing wrong, eh? I break the law plenty of time, and I gotta do my time, brother. And now I'm sleeping in my bed. And I accept that because I will do what I will do. But now I'm trying to do it right. What if it's right? And I pupuli, I go to school and look at girls eat lunch and gamble. But I'm gonna tell you something. The man upstairs or the queen or whatever, this Aina, this spirit inside here telling me to do what if it's right. So only one caregiver I go and I do my aloha. I don't expect nothing. So you get need help, aloha. I only eat for work.
Miles. And then Michelle.
Hi, I'm Marlene Blando. I work for High Regency Waikiki. To me, PLDC gives the state of being a mute, but then they can use the silence of voices. You see it here, our public comments like they have to do today. Then again, they may not under their own rules. They don't have to. And once we're done saying our pieces, who's to say they will take anything we'll say and into account? We're looking at you guys' board, appointed, not elected. They schedule most of their meetings at times where the public can't attend. When they did say evening meetings, only one member of the PLDC board actually showed up what they want to say. Even where we've spoken, our voices have not been heard. I would expect anything different in the future, especially if the rules don't force them to hear our voices. As I said today, that's why the rights of Hawaii's working people is to repeal the PLDC. Thank you.
Then Juanita. And Ralph.
Good afternoon. I'm Michelle Matson. I'm president of the Oahu Island Parks Conservancy. As a member of and the Kapi'olani Park Advisory Council. I'm here today because I want you to know I'm going to strongly and actively support the repeal of the PLDC. These proceedings have been an insult to the public, and I know that you are not directly responsible for this type of process. But I have things to say about the rules and the statute, which I would like to put on record today. Because two of you here I have worked with, I respect, and I know you will understand how everyone has felt and will continue to feel. The PLDC's governing statutes provide that any state or city agency may transfer development rights for lands under their jurisdiction to the PLDC if the PLDC board, a majority of 3 individuals, finds that such public lands are suitable for its development purposes. The PLD statute carries the force of law. However, this statute, which supersedes any rules, can be loosely interpreted and broadly states the PLDC project shall be exempt from all statutes, ordinances, charter provisions, and rules of any government agency relating to special improvement district assessments, requirements, land use, zoning, and construction standards. These are open-ended exemptions. Chapter 343 and 205A are environmental impact disclosure and shoreline protection statutes. Statutes from which the PLDC is exempt in its own governing statute. And Honolulu's established zoning regulations are governed by the city land use ordinance. PLDC is exempt from ordinances. The PLDC rules have no substantive criteria to protect natural and cultural resources. PLDC proposed projects cannot cause harm to natural resources. DLNR's mission is to protect and manage state public lands and natural resources in the public interest. If DLNR lands are transferred to the PLDC for development purposes, these lands will be lost from the stewardship that DLNR is mandated to provide. So in reality, the PLDC will be paying DLNR for giving up public lands for PLDC development unrelated to DLNR's mission. Further, once transferred to PLDC control by any agency, agreement, or conveyance, these public lands will no longer be defined and protected as public lands according to Act 282 of this year. How will public lands be protected if they are no longer public lands under Act 282? Instead, under the fatally flawed PLDC statute, our public lands will be slated for exploitation by the PLDC, quote from the statute, for local, national, and international markets. The PLDC is enabled to authorize unfettered development, conservation lands, agricultural lands, school campuses, open public shorelines, public lands with documented significant Malcolm Mackay view plains, such as Kakako Mackay. The Coastal Zone Management Act protects our fragile coastlines. The public is exempt from the legal directives of the CZM program, which is intended to protect Hawaii's valuable coastal systems, ecosystems, beaches, marine resources, and public beach access, and to ensure a balance between development, public use, and preservation for future generations. In addition, the PLDC is exempt from shoreline setbacks, including the prohibition of structures in the shoreline area. This is contrary to growing efforts to move new construction away from the shoreline in anticipation of documented sea level rise. Because of the PLDC's governing statute and that the fact it is fatally flawed, important agricultural lands necessary for farming and sustainable food production purposes can be freely developed. A token strategic plan developed by the governor and Senator Dela Cruz purports the PLDC won't develop important agricultural lands. But this strategic plan does not carry the weight of law. It is simply a proposed placebo supplement to rules written and rewritten to sugarcoat the PLDC's fatally flawed governing statute. The PLDC is clearly exempt from permitting and zoning processes that normally enforce legal safeguard. And the proposed PLDC rules continue to not clarify how significant laws will be followed in view of PLDC project exemptions. Act 282 of this year lifts limitations on zoning use, heights, density, and intensity of PLDC developments. How will significant standing land use laws be monitored and enforced given the PLDC exemptions to permitting and zoning processes? Where is specific criteria for project approval? How and when will the public be notified regarding specific exemptions that apply to each project? The flawed PLDC statute enables the Hawaii Community Development Authority to assist the PLDC in identifying public lands for development, determining the highest and best revenue generation from public lands identified, entering into public-private agreements with developers to develop the public lands identified, and to lead the development, financing, improvement, or enhancement of the selected developments. This is in the governing statute. I will be concluding shortly. Why are developers of prior projects who have violated environmental laws or have broken compliance commitments allowed the special exemptions and privileges offered by the PLDC? Why should developers be allowed to negotiate deals in secret without competitive bidding? Why is it that 1/3 of the PLDC's proposed rules are not being brought up at this hearing? Section 303, Facility Infrastructure Development and Property Assessment Financing Accessory to PLDC Public Land Development Projects. These proposed rules establish a procedure for the PLDC to undertake and finance public works projects, including highways, storm drainage systems, utility corridors, water systems, sewer systems, and other public facilities to support PLDC land development projects by taking any land needed for these facilities and assessing area property owners for the cost. In conclusion, the PLDC must have an open and transparent process for accountability and to prevent abuse. PLDC's governing statute is fatally flawed because there is no definition or standards of appropriate or culturally sensitive, and the rules have no enforceable protections for Native Hawaiian traditions and customary rights. So how can the PLDC proceed to comply with the statutory purpose of administering an appropriate and culturally sensitive public land development program? There must be meaningful community input on each island where a PLDC project is proposed to take public land. Yet prior to approval of the community-based master plan for Kaka'ako-Makai, the HCDA executive director, who will be advising the PLDC, stated that the community-based master plan was merely a flexible conceptual framework subject to foreclosure. And that is a quote. Thank you. This was followed within a few months by certain legislators and developers working together to remove HCDA's statutory requirement to collaborate and consult with the community, clearly a forerunner to the intent to dilute the public process replicated in exemption bills introduced this last session to benefit the PLDC. My final sentence. Given the continuing wide gaps in the PLDC's proposed administrative rules and the fatal flaws within the PLDC's governing statute subject to myriad interpretations now and in the future by unknown persons, there continues to be no question that the sugar-coated rules remain deficient and defective, and that the PLDC statute must be repealed and the PLDC abolished in the public interest. Thank you.
Aloha mai kako. Mahalo to our board members and director for allowing me the opportunity to testify. My name is Juanita Mahiena Brown Kawamoto, and I am here as a Native Hawaiian citizen advocate that supports the repeal of the PLDC. How many times in Hawaii's history do we have to continue to allow bad legislation that disavows and omits the participation and inclusion of the people of Hawaii? The legislature, the current executive administration, and the private business sectors that lurk in the background while this horrible second coming of the short-sighted, ill-advised, disastrous redo of a 2011 Mahele commences to take advantage of an economically diseased state of affairs that expects to solve our financial woes by short-sighted rules, policies, practices, and procedures. The PLDC will commit our last remaining precious resources to joint ventures with qualified persons for the development and financing of future projects in unsuspecting communities without the required input of the people, because we are trusting a single individual to appoint members of a board that has minimum to no obligation to have to include the people in the decisions for the development of our public assets. The creation of this bad legislation and its evil twin, the Hawaii Department of Agriculture's Agricultural Development Corporation, will throw our public trust in government into an abyss we will not be able to survive. No manner of amendments to this unjust and illegally devised form of bad legislation will redeem the PLDC or the roles played by deceitful legislators with self-motivated agendas. Please follow the right direction of the good leadership that is currently introducing bills to repeal the PLDC. Hawaii cannot afford the devastating effects from this kind of bad legislation with a corporate institution that can disregard He Hawaii Au. We are capable of so much better when we are inclusive of our community and hui kulana kauhale. Mahalo for your attention to these matters.
Hi. I'd like to thank you for allowing us to come and speak. I know democracy can be a little messy sometimes when Yeah, sometimes our democracy has gotten so bureaucratic and so big, it's almost like just a branding label that we have a democracy. But, you know, maybe it's just a democracy between a Coke and a Pepsi and a 20-story building or a 40-story building, and there's really not much input, but we still have to open the doors and let the public in. And my hope is that the people that crafted this legislation, from the governor on down, and those legislators and congressmen, that they would at least take the time to listen to the transcript or watch the video of these people testifying, because this is a backbone of democracy, of hearing the people. And I would just say we had a person testifying here about the benefits of fast tracking, going beyond the rules and regulations that have all been put in place by people and organizations and governments. Well, we can see what happened with fast food. I've been in Hawaii almost 40 years, and I was shocked how many fast food places there are. Fast food is so destructive to your health, diabetes, obesity, etc., that there's a whole movement now called the slow food movement. Eat real food. Cook it yourself. If you want French fries, make it yourself. So I think fast tracking is very dangerous. There's a whole book written on government's fast tracking thing called the shock doctrine. I advise anyone with any interest to read it, by Naomi Klein. It's all about, in a crisis, certain greedy elements, corporate elements are lurking in the scene, and they try to go in, they try to change the rules and regulations that will benefit them. So many times you saw this happen after 9/11. We got this potentially democracy-killing Patriot Act. We got 2 huge resource wars that were told we needed to have that really benefited transnational corporations. We got a bailout, one of the largest bailouts and giveaways of wealth in the history of the world, where the average citizen's money got kicked up to big-time corporate and Wall Street gamblers who stayed a little too long at the roulette table, lost their pants, and came begging to us to bail them out. And so this is what we're seeing all over the world. All over the world, the corporations, the big money interests are drooling over the commons, the common wealth that the people have, the schools, the land, the prisons. You start corporatizing schools and lands and prisons and all this stuff, and it'll be the Walmartization. There'll be a few people, a few shareholders making all the money. Look at the corporate list of the most wealthy people. 5 of them are the Walmart heirs. But do people at Walmart make any money? No, they have to go on food stamps. So this is the nature of what our problem is. And if you allow corporate interests to come in to try to make money on the commons, it's just a catastrophe. We can go slow. We don't need to be in a hurry. The faster we go, the more we're going to destroy this planet. It's just very, very obvious now. That atmosphere is only, you can drive up the Mauna Kea in about a half an hour, and you can't breathe up there. That's how little our Earth is. There's a little envelope. I go to India for a month every year, and other places around there, and they've got development you can't believe, but you can't breathe the air. You get sick within a couple days there. I get out of there right away, but just spending one night in Delhi, I get a head cold. People have asthma there. People are going to die. We don't need to exhaust this planet any faster. We all have a job to do. We want to create jobs. It's the same job that every citizen has ever had on the face of the earth, and that's to provide for his family, to keep the environment clean and safe for his predecessors, because we live in a circular world. We don't live in a world with endless expansion unless we can create a rocket ship and go to another planet and screw that up. Thank you very much.
Colvin, and then Anthony Alto.
Good afternoon. My name is Stuart Coleman, and I'm the Hawaii coordinator of the Surfrider Foundation. And I appreciate you hearing our testimony. You've heard a lot of people, and this is one of probably the most controversial issues I've seen in a long time. I think overwhelming amount of the testimony is against it. But I'd like to say, I don't think people are necessarily against your aims. The idea of some public-private financing, because the agencies are underfunded, this is happening across the country. As the previous gentleman said, the counties and government agencies are underfunded, and there are projects that could be done. I don't think this is the way to do it, because the analogy I use is when you're looking to our infrastructure across the country is decaying, right? We have bridges that need to be rebuilt and repaired. But instead of working on the existing laws, because anybody who's gone through a permitting process knows there's a lot of room for improvement, and they need to be, improved so that, these things can be expedited. Everyone gets that. Government bureaucracy can be a problem. But instead of improving that, you're doing an end around. And it's a shortcut. And the shortcuts often end up taking the longest amount of time and causing the most amount of problems. And so if you look at, when, the previous governor tried to go and move the super ferry through, and tried to shortcut a lot of the environmental precautions there, that created a nightmare for businesses and government and the people alike. And I think that's what we're creating here. By trying to bypass a lot of these, for the building codes, for the environmental, and for the cultural. Now, I know for you all and for people above who are pushing this, it seems like, no, we're going to have all those things. There's still plenty in place. But if you look at there are already places that are targeted, and we've heard of places, like the natatorium, it seems like a great thing. That's been decaying by the shoreline. Of course we want to come in there and do something, but it's not that easy. I've been studying the natatorium issue, for more than 10 years, and it's very complex because, this is a park. It was created as a memorial park. You can't, even though it seems promising to rebuild the stadium and do something by the sea, when you're talking, a commission studied this for over a year, and they found that the best way to do it was to build a beach, to return it to the people. Well, any private group that comes in there, any company, that's not the thing they want. They want to privatize it. They want to create a show, like a hula show or something that can actually make money. And it seems good on the surface, but it's not. This is the last local beach, and so you have these places all across the state that are being cherry-picked and saying, look, we could do great things with this, but these steps are in place for a reason, for public input. And I think even rushing this bill through the legislature, having been there, the testimony was overwhelming against it. And yet the powers that be, the people who know, were like, no, this is good, we're moving it through. And that just right there kind of betrayed the public trust, because it was like the overwhelming, as you can see here, testimony was against it. So I would just caution that, in trying to expedite the process, we might be creating a nightmare for you all, for, other government agencies, for the people and the companies that are going to be involved. So I would ask you to, kind of reconsider a lot of these rules. The public financing, I think, people could get behind some of the aspects, but expediting all the environmental building codes and those reviews and regulations, I think, would not be a good idea. Thank you.
And then,
Good afternoon. Aloha. Thank you, Director Hariguchi, members of the board, for this opportunity to testify. I'm chair of the Oahu group of the Sierra Club, but I'm testifying in my individual capacity. And in some ways I feel a need to apologize because I'm a Malahini. I've only been living in Hawaii for 7 years. And I know the great work that has been done by people at DLNR, by Chair Aila, who has almost legendary reputation. And it's almost upsetting, I think, that this has become such a confrontational process. And I suspect it has been at times unpleasant for you personally. And yet, I can't help but feel that there was no way to avoid it, given how this whole process has come about. And I have to echo the disappointment of so many people who have testified. First, that this hearing is being held at a time when most members of the public aren't able to attend, and it's only being held here on Oahu. Act 55 was passed, as we all know by now, by the legislature in a pretty murky process. It was very close to being a gut and replace bill by the time the last elements of it were added. And I believe this flawed process by which the PLDC came into being placed on you members of the board, an even greater burden to ensure that there was an open and transparent public process in establishing its rules. The public opposition to the current draft has been voiced clearly in the first round of hearings that were held here and on the neighbor islands. But I think it feels to many people that you failed to heed the voices. And this lack of responsiveness can't help but cause people to fear what the board will be doing going forward. I don't know that people individually think that you, Mr. Director, or Chair Aila have bad intentions. But we're not responding to you as individuals with your history of environmental action. We're responding to you as members of a board that has been created by the legislature, which doesn't have enough rules to ensure that the public's interests are being protected. Indeed, like many of the volunteers at the Sierra Club, I didn't originally intend to oppose the PLDC outright. We understand the need to raise money for many of the good things that the DLNR does, such as protecting conservation watersheds, which are woefully underfunded. As you know, in the last session of the legislature, we did our best to help try to raise funds for that good work that you guys do. We understand the need to invest in improving public facilities, such as the Aloha Harbor, which is what we were originally told Act 55 was all about. And so through our director, Robert Harris, in the first round of hearings, we actually testified not for the abolition of the PLDC, but for amended rules. And Robert Harris's testimony was echoed by dozens of other experts who specifically called out rules that could be changed and amended to give us the confidence that this actually would be something to the benefit of the public, not that something that would work to our detriment. But it appears as if you've chosen to ignore all of those testimonials. What was it that we were asking for? We asked for rules that would ensure that the PLDC would not be able to authorize development without any substantive criteria that protects natural and cultural resources. We asked that proposed projects be required to establish that there isn't significant harm to natural resources and that there will still be public access. What's wrong with what we were asking for? We asked for rules to ensure that the PLDC wouldn't be able to authorize development in the conservation district or along our shorelines or on important agricultural lands. Aren't conservation lands by definition supposed to be protected? Shouldn't ag land be used for agriculture? Our coastlines are particularly fragile, which is why we passed the Coastal Zone Management Act. Shouldn't the PLDC be required to follow the directives of the law instead of being exempted from the law? We asked for rules to ensure that the PLDC should not be allowed exemptions from the law that would allow it to do business with the developers that have environmental and labor law violations in their past. These are reasonable concerns, and your failure to incorporate them into your rules is what is leading to an ever louder and stronger campaign to abolish the PLDC. And in conclusion, if I may, it's the failure to do anything, to amend these draft rules, to acknowledge the hundreds of pieces of testimony you have received, both in writing and in person, that leads so many to fear that it's the democratic process itself that's being subverted. And that makes many people feel that in some ways you're just going through the motions. that you're sitting here hour after hour listening to this stuff, but it's kind of going in one ear and out the other. I, for one, choose not to believe that you are just going through the motions. But I appeal to you to prove it by radically revising these rules. And if you don't, then I think what will happen is that there will be an ever louder and stronger public campaign to abolish the PLDC altogether. Thank you very much.
And then Michael Davis.
Good afternoon, Hariguchi and the DLNR over here. My name is Michael Tada, and I advocate for the repeal of the PLDC. I advocate its repeal. I'm a born and raised here. Okay? I have seen what we are doing to this island. Yeah.
Sorry, just a second. I just want to check, is everyone able to understand? Yeah, okay. Sorry, I just wanted to check Michael so that, to make sure that they're getting what you're saying.
Do you mind, Michael, having a translator?
No, I don't mind.
Leilani?
I asked you to repeal the PLDC.
He's asking to repeal the PLDC.
Because having been born and raised here, I used to love to go to the countryside and to Aloha and to, Wakaha. And every time we used to pass to the pineapple fields, the sugarcane fields, the only agriculture, yeah. And one thing when I was growing up, I remembered learning that the sugar industry was our number one important industry. Well, as well as the pineapple industry. But then, a few years ago, I thought it was shut down. And because of some land development. Yeah. Well, I understand why. But I actually repeal the PLDC, but not only for us, but I believe that we need to consider the feelings of the native Hawaiians. They have lost so much land. People been taking land, they've been taking land away from the native Hawaiians for so many years. I'm not Hawaiian. I was born and raised here. And I know what history.
I know our history.
I'm against the PLDC.
And I'm against the PLDC.
For the main reason.
For the main reason.
One of the main reasons why I'm against the PLDC because I'm against taking any more land. If you have that kind of land, why don't you help and sell it to the native, or give it back?
Give it back.
To the native Hawaiian. You know, how dare we think, how dare we say, oh, we can do this, do that to the land, and not care about what there are homeless people who are Hawaiian. There are native Hawaiian people who are homeless. And you to me, that is the most selfish, evil act. You can, that is not aloha. That is not ponyo. That is reprehensible. That is, and I fully advocate the repeal. Don't do it. Don't do it in Hawaii. Don't do it in Hawaii. You know, don't take away from, you know, agriculture is important to Hawaii. Agriculture helps agriculture helps our islands be sustainable. To please, don't allow PLDC to do anything. Let the people of Hawaii, particularly the native Hawaiians, I just, let them have a day. We don't need that kind of money. We need more agriculture. We need more pineapple fields, sugarcane fields. Cattle. Please, we need more agriculture. We're on an island, and if we do anything about hurricanes, there'll be no more import. If there was a major hurricane, there'll be no more import. And we need to think ourselves, God, we used to drink the cattle, pineapple, sugarcane, corn, and everyone develop. Then, be real.
April Daly and then Dustin Marca.
Hello, Lloyd. Hariguchi. My name is Michael Daly. I'm not a native Hawaiian. I'm not even a local boy. I arrived here 22 years ago, settling here from Australia. I know a thing about Universal Declaration of Human Rights and international law, and I'm aware of the Hawaiian history. I support the Hawaiian Kingdom and coordinated Earth Day on Kauai Island for 7 years. I also now support Deoccupy Honolulu. I'm opposed to the Public Land Development Corporation. I believe the injustices and devastation projected by the establishment and agenda of the PLC must stop immediately. I'm referring to its role in wrongfully controlling and its wasteful development of property across Hawaii. Act 55 mandating PLC must be repealed. The issues have created such concern that proper hearings with proper notice given to people and at proper times and places so public can attend must be arranged in all islands. We are not Russia. We are not China. I heard it said in the previous testimonial. Well, in an anti-democratic way of globalization, yes, we are. Hawaiians, Russians, Chinese, U.S. residents have to change that. We have to stand up for real democracy, workers' rights, human rights, land rights. I note the Occupy Wall Street movement is addressing that and needs support. Corruption, lack of process, destruction, confusion and frustration should be no surprise to any of the people here, not even yourself, knowing that Hawaii is an occupied region. A moratorium on land development or controversial development projects must take place. It must take place in the light of the admission of guilt on the part of the USA in the overthrow of Queen Liliuokalani in 1893. That admission of guilt is U.S. Joint Resolution Public Law 103-150. It is backed up with overwhelming evidence under international law that the government and subjects of the sovereign Hawaiian Kingdom never relinquished their sovereignty. The nation still exists, but is impaired through the illegal occupation by the imperial will of the USA. Public Law 103-150, signed by President Clinton in 1993, stipulates reconciliation. This must be done between the two parties, the two nations, the Kingdom of Hawaii and the USA, under international law. The current way of addressing reconciliation is grossly unsatisfactory and is still illegal. I'm referring there to the attempted deals between the State of Hawaii and OHA, Office of Hawaiian Affairs. This is not correct. It should not be lost on anyone that OHA is a state agency, not an independent entity somehow representing the lineage of Hawaiian nationhood as it was working the day before January 17, 1893, when Queen Liliuokalani was rightfully the monarch and head of state. I have three paragraphs, please. Quick. All right. I will be submitting this in testimony, and I'll appreciate you looking for it. The Hawaiian government and Crown Lands is a shameful act of theft and confusion on the part of the USA and goes back to Queen Liliuokalani's day. It comes up under every administration, whether it's Cayetano, Lingle, Abercrombie. It doesn't matter if it goes back into territorial days. Those estates are still under question here, and the PLDC is part of the instruments used to continue an illegal occupation, and I believe that you need to address that in your own souls, apart from anything else. All right, I'll just sum up. The world must know that Kanaka Maoli, as indigenous people here, and the multicultural Kingdom of Hawaii are key in turning global destruction around and back into sustainability. The PLUC is part of an imperial destruction, a genre of colonialism that goes back 1 century. You are not about sustainability or childcare or child future. We must reinstate Hawaiian law and ways. You are misled is what I'm seeing, and that the PLDC must be stopped now so that the legs of righteousness and sustainability can be unchained. Thank you.
Aloha. My name is Dustin Barca. I'm from Kauai. I'm a professional athlete from Hawaii, and I represent the people of Hawaii and the future of Hawaii. I find it sad that there's so little people that even know about this meeting today. And I find it sad the goals of the PLDC. It's almost like the second overthrow of Hawaii. And I find a lot of the goals and actions real shady because they're so secretive. I'd just like to say that the future of Hawaii is in you guys' hands here. And people don't come to Hawaii for buildings and more, you know, excuse me. People come to Hawaii for Hawaii, what Hawaii is, and that's green, and that's organic, and that is natural beauty. They don't come to Hawaii for buildings and more buildings, and, you know, Hawaii is a free place. It is a special place, and I feel that Act 55 is taking a lot of the special away from Hawaii. And thank you for having me. Aloha.
Aloha, my name is Wayne Takamini. I've been recognized as the chair of the Kaka'akamakai Community Planning Advisory Council. I was the chair when we created the approved Kaka'akamakai Conceptual Master Plan, and we worked with the HCDA. Our Citizen Advisory Group was created back in 2006 through a HCR 30 in the legislature, which had language that the HCDA create a citizens working group to work with them for a master plan for Kaka'akamakai, and that master plan was approved last year. So currently, I have experience working with a authority that's probably is the advisor for the PLDC. I think that there's definitely a difference between HCDA and the PLDC. The HCDA has been operating under rules that have been set for many years now, and the PLDC is a relatively new organization that, from my understanding, the rules are not as elaborate. Some of the rules that the HCDA authority has to work under, the PLDC is exempt. And for this reason, when I look at researching this hearings for these rules, I see a lot of the communities on the neighbor island, especially the Hawaii County Board and the Kauai County Board, have taken resolutions unanimously to repeal Act 55. And also Maui has taken a step to have a proposal. They have unanimously voted on creating a proposal, again, to repeal Act 55. So I see a lot of opposition to the bill and to the PLDC. I also talked to people in our area, and a lot of the concerns is that Kaka'akamakai has special laws that that prohibit residential in the area. This was brought up in 2006, and also the sale of state land in Kaka'ako is also another bill that was created and is now law for Kaka'ako. So these rules will be compromised under the Act 55. And then there's also a lot of zoning, it being the coastline area, coastal zoning management rules go into place, which PLDC would be exempt. So in our process, we have created a community plan which shows what the community desires, and right now it's going through another process where OHA, which now owns the land, will be looking at this too. So when I talk to OHA, because we are kind of joined together at the hip, we created this conceptual plan, and OHA has helped with the planning process. Now, so as we go forward and the HCDA proposes changes or development in the area, then of course, again, OHA and our organization talk together to see, what's going on. And I think they're opposed to this rule also. They've submitted changes, and you folks have not come back with rules changes that incorporate some of their concerns and some of their suggestions. So, I see the process is not forthcoming both ways. So, of course, the community is having some problems trying to digest how can we work with this agency that has the hearings, has a lot of people in opposition, and then we give them suggestions and they throw it out the window. So we basically want to try to see how this can go forward, and right now it doesn't look good. I've suggested to people in our group that we try to send it back to the legislature so hopefully they can untangle this mess. But as far as these rules today, as it stands, I'm in opposition, and I am the spokesman for the Kaka'amakai Community Planning Advisory Council, but I'm speaking as an individual. I feel that these rules are changes for today is not what the community needs. Thank you.
Good afternoon. Thank you very much for allowing me to address you all this afternoon. My name is Kilikina Kekomano. I'm a Kanaka Maoli. My 11th great grandmother comes from Big Island, Napopo, 1725. I represent the Aloha Kikyo Ainas of Hawaii. I live in Oahu. My purpose here is to publicly renounce this Act 55. It is emotional for a Kanaka Maoli person when we lost our country January 17th, 1893, and then we were illegally occupied permanently from August 12th, 1898. In doing so, my country, beloved country of Hawaii, was never conquered, was never acquired, and there was never a treaty. In understanding the ramifications of that, the April 30th, 1900 Organic Act, which is all your laws in this state of Hawaii, has the jurisdiction of a territory, because it is a territory. The territory of the Act of April 30th, 1900's jurisdiction is American Samoa, Northern Marianas, the Virgin Islands, Puerto Rico, and District of Columbia. My point is I can't understand what laws you're executing in your jurisdiction to commit malicious, premeditated malfeasance on the Kanaka Maoli people, on the people of this land, and on my ancestors that have never relinquished one title under the Royal Patent Lands of 1855 under King Kamehameha's probate will. Those 1,800,000 acres are in perpetuity. And if I need to define that for you, it can never be sold, taxed, liened, or mortgaged. In effect, your laws are totally not in effect. You have no jurisdiction, no warrant of law, and no warrant of treaty. You have the United States of America needed a treaty for its major three accusations, which was from Napoleon in 1803, the Louisiana Purchase, the American-Mexican War, the Treaty of Guadalupe Delgado in 1848, 15 million, and don't forget Russia with love, 7.2 million in 1876. My case in point, there is no treaty that allows any law other than kingdom law. May I remind you, during World War II, when the United States occupied Japan and Germany, common law has been exercised in every country that America has occupied, with the exception of the Kingdom of Hawaii. So our laws are not gone. 1-1 under Williams, Professor Judge Williamson, Richardson, that was for excess. We have more than excess. We have all the laws. My family and heirs, with our DNA, we are the law. We own those patents. And now you're going to develop land that you have no warrant of deed or title. You don't even have a treaty to exercise your laws. I am grossly confused. How can you pursue this malicious, premeditated malfeasance on my people without warrant of deed or title? That was all rescinded January 17th, 1893. There was no Bureau of Conveyance. There was no notary. And then you had 50 U.S. American businessmen and sugar plantation owners, with the aid of the USS Boston of 157 men with 10 officers that came in on a man of war, broke international law, occupied our islands, raped the Queen of her land, her resources, her gold, and 46 international neutral treaties. Now show me, I don't understand what law you're using. There is no law in this state. It's a corporation under an act of the District of Columbia, which is a territory. Thank you.
Good afternoon, and I'll say thank you and shame on you guys, both for having just one public hearing for these revised rules. I think it is short-sighted to only have the meeting here in Honolulu for the second round of these rules, because in my opinion, these rules are still woefully inadequate to meet the intent of what was passed. Whether I agree with what was passed or not is a whole nother animal. I have just provided some copies of written testimony that actually go in and talk to specific sections in your rules that I have concerns about, one of which, again, is going to be public acknowledgement and allowing the voice of the public to be heard, albeit you have this flow chart, this wonderful looking flow chart, that is not reflected anywhere in your rules. The only required meeting is the one meeting that you have in section 13.302.32. The one thing that was interesting is I've been listening to a lot of people this morning, and while I agree with a lot of what has been stated, and you'll see that in my written testimony, I did just a quick search for my own edification this morning to make sure I was not missing anything that I thought might be important, because my largest concern the last time I spoke before you is the rules prior to this version, and even this version, does not adequately reflect what you may or may not do. Again, as you've heard, there are concerns regarding what you may or may not allow to occur in conservation lands, what you may or may not allow to occur within agricultural lands. And I think this is indicative of the fact that your rules are inadequate as per the bill as it was passed. And I will reflect on page 15, which was in the Senate Bill 1555, and it states, the corporation shall prepare the Hawaii and establish goals, objectives, policies, and priority guidelines for its public land optimization development strategy. And then it goes on to list what the plan will include. Well, interestingly enough, you do not even address in your rules that you are even going to put a plan together. And for most organizations, when something like that is in the statute, that becomes part of your rules. There should be rules as to how you're going to develop this optimization plan, how the public is going to be able to input and exactly what's going to be in there. I think if you had even acknowledged this and stated that within that optimization public land plan, that you would address all of the issues that have been coming up every time I've been to a hearing here, there would be a lot less consternation regarding what you guys are planning on doing and how far you plan on going with this, let's go develop everything within that can produce revenues so that we can go take care of whatever conservation land is left. If you have 100 acres of conservation land and develop 75 to go produce money to go take care of the other 25, I don't call that plan an optimization plan. And neither do I believe that that was the intent of the PLDC with how it was formulated. So I would really, and it's that piece, by the way, is not in my testimony because it was something that I just skimmed through the bill again. But I think that you owe it to the public to be able to address that section of the law in your rules, because that is what a lot of us have been stating. You have not illuminated for us how far you're going to go with taking the public lands and developing them to the detriment, potentially, of why they are public lands today and why they are protected. And that, I think, is a major fallacy of your rules as they are currently written. And I really would recommend that before you take these rules, even the second draft, and say, yes, we're going to go with it, that you really, really consider going back, looking at the law as it's written, and if nothing else, adding this entire piece back into your rules. Because right now, you have nothing but a major uphill battle ahead of you with the way the rules are written, much less the way the law is structured. Right now, you have not allayed any fears from the public of what the potential of this unfettered development could potentially bring forward on the state and our public lands, and what people truly hold in their heart as what this state is all about. So my recommendation is, I don't think due diligence has necessarily been complete in drafting these rules, and I think you need to go back, review Act 55, and write rules that reflect everything that's in this act, and not just, here's the technical aspects of how we're going to work with the developer versus this guy or that guy, or, you know, we're going to go to the title agency after a planner or developer has come to us with a concept. The title agency should be gone to before it ever comes to you, in my mind. But I think this, after reading this again today, is really critical. And this is nowhere to be found in your rules. And I think it's really critical. Thank you.
Good afternoon. I appreciate your having this hearing on Oahu. I live here, and so it's fairly easy for me to get here. But I really feel that you ought to hold this hearing on the neighbor islands as well, since, as Senator, Senator from the Kauai, he said that he said 1/3 of the people live in the neighbor islands, and of course a lot of the land that's affected is on the neighbor islands. I really feel that you need to hold the hearings on your revised rules there so that they can react to these rules. A lot of them, I'm sure, have studied your first proposed rules, and I'm sure that they have or will study your second proposed rules, but you have to give them an opportunity to testify. To me, this is like when you have children, you have one child and you favor that child by holding the hearing here, but not on the neighbor islands. It's not fair to the neighbor islanders, even though I live here. The other point I wanted to make is that I was very disappointed to see that there wasn't a full board. I understand that there are 5 board members, and I see Mr. Aila, and I saw earlier Miss Alice Evans, Mary Alice Evans, and I presume she's a member of the board, but that's 2 out of 5, and I understand that Mr. Hariguchi, you're the executive director and employee. So where are the others? I thought that because it was going to be held during the day, that more of them would be able to attend. So anyway, I just wanted to make that point. When you have a hearing, it would be nice if a majority of the board members were here to hear and to see the testimony. Thank you very much. Yes. Oh, this is for myself.
Abundance of caution, we're going to a more strict interpretation. So only 2 board members are here, and that's why you only see 2.
Can you appear? Oh, that's strange. I've never heard that interpretation. Could you give us the names of those attorneys that gave you that interpretation? Oh. Uh-huh.
This is happening under Chapter 91. So we have a difference of opinion right now.
Mm-hmm.
So like I said, in an abundance of caution.
Mm-hmm. Oh, it's the first I've ever heard of such a strange rule or interpretation.
Further, we did have 4 board members waiting to come to the meeting.
Oh.
But because of that, Mr. Aila mentioned. Yeah.
Oh, my goodness. All right. Well, thank you for that clarification.
Mahalo nui loa for this opportunity to speak to you, and I apologize for missing my name the first time around. I was coming from far, and my car is very, very slow. My name is Laulani Teal, and I work as a peacemaker. I have a project called the Ho'opaipono Peace Program, and I work with communities and families and organizations in helping to resolve conflict. I was one of the very few people who, I believe, attended the legislative hearing on the PLDC. The hearing that I went to, from what I hear, was pretty much the only public hearing that happened in that round, and I was one of 3 people in the room. I didn't testify because, to be quite honest, I only heard about the PLDC on my way over there, and the hearing was over before I could actually read through the entire law and understand it, what was the measure that was being passed. So I think what I'm saying here is that my understanding of this situation, based on my personal experience with this, and also with talking to many people and hearing what's going on today and elsewhere, is that people are feeling very strongly that they have not had an ability to give mana'o on this process. Not in the beginning, not in the creation of the process, not in the creation of the rules. And I think that some are definitely feeling concern that they are not having their mana'o heard right now. I am very concerned as a peacemaker that if these administrative rules are passed as is, that the people will genuinely have no choice but to fight. I would prefer not to see that. I understand that there are some good intentions. While I don't agree with the way that they are put forth myself, I do understand that people are looking for solutions. They're looking for ways to repair stuff that's broken. They're looking for ways to figure out answers to problems. That is valid, but an answer that creates potential damage is certainly going to cause great conflict if the people are not listened to along the way. And right now what I'm hearing is that the people are not satisfied with the administrative rules that are put before you. I know that repeal of the PLDC is a legislative act, and you know that you folks don't necessarily have direct control over that, but there is much that you have control over. There is much that people have said, and in the interest of peace, there is a way that you can put the brakes on your own organization, on this corporation. Put the brakes on, because that is what you have the power to do, to put the structures in place that will prevent damage from happening now, in the future. That's the way that we all need to work with each other. So mahalo very much.
Anybody else would like to testify?
Aloha. I'm Ululani Bernie from Kahana Valley. And, you know, I wasn't aware that your rules had already come out by listening to the first round of hearings that you had, but I was just told that it was online. We came because when I got home from my Kahana planning meeting, it was on TV. You were being televised on TV, and I thought it was important enough for me to come. What I'm here for is to let you folks know that we just had an Association of Hawaiian Civic Club convention in Washington, D.C. This particular issue, PLDC, was also discussed in one of our committee meetings, and quite lengthily at that as well. We had Makana Paris with us in that particular meeting, and of course a lot of concerns went pro and con on this. One of the things that I'm happy about is that many of the counties are now presenting their own proposals of repealing this Act 55. We went into our committee meetings with open minds on how we could, you know, how we could see if we could perhaps participate in the rulemaking, if you will, because you know that when I came to the first hearing, I said, boy, you all jam up. You should just, you know, kind of throw the towel in and retire. Okay, so, you know, I'm the first one that had said that to you. But I just want you to know that our people are very, very concerned. And then having heard all the rules, you came up with the rules. And I work very closely with many people, and even Cynthia. But in that particular committee meeting, many people that are on the outside islands as well as here, you know, brought up their concern about this particular issue. We have been really, really concerned that a lot of the rules that were set on the table at that first meeting is not, you know, has not been incorporated in your rules, your administrative rules, and maybe some of them have. But the majority of what our people was feeling was that we would try, in fact, to try to see how we could work with you folks with administration rules, even though those that want to move towards repeal was more solid, to say, and so trying to listen to both and trying to pass it on committee on what we would stand for as an association, plus what we were going to be against, weighed very strong in both arenas. So I think what I wanted to say to you is that really listen to what has been said. I sat there reading the newspaper and listening to what was going on, and took notice of the House having this tug of war and leadership as well. Who's going to be the next leader, on the House side? But putting yourself out there, and wanting to be involved, it all has to do with service. If we're listening to all of our people and then we're not hearing what they're saying, we're not hearing their concerns, it makes it all for naught. That in the participation process, whether it be citizen participation, community participation, and what, there has to be a listening ear what is happening over here. This gal that just came all the way from Waianae, she just went bang, 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 one after another, on all those things that had to do with our kingdom. It's not something that I don't know about, a lot of us don't know about. We just don't put it all on the table. But she just went bang, bang, bang. And it's so true that, really, our people have not relinquished their kingdom. That anything that has to do with it. My first thing that came in my mind about the Public Land Development Corp was that public land. Well, all these people coming in to testify. Our public lands, to me, is really our ceded lands. We have so much to do. And our ceded lands are lands that was ceded back from the United States, the federal government, to the state of Hawaii in 1959 when we became a state. It's supposed to be in trust. It's supposed to be put in trust. For the time when it comes that all those things that was done to us with the overthrow of our kingdom might be put in place again. So, by usurping all of this and using up those lands that supposed to be put in trust, it's like a no-no with a lot of our people. So, gotta take into consideration, you got the best person right here on your board. He knows everything that has to be done. And yet, we know that there's a shortfall in the budget. We know that there's a need. When you put up there about state parks, come from Kahana State Park, we had to fight 30-something years just to be able to live in the park. But our bathrooms are not all dilapidated like that because we have a lot of groups coming in. There's some really, bad places. I see Malai Kahana on the screen. And our Olelo Hawaiian Civic Club, which, I'm a part of, we basically came forward to see if we could get the lease for that place, and have our members run that park out there. But many of our members were really older. We were even underneath the cabinets over there trying to, fix up the sewage line and everything to make it work out there, and we do all our own cleaning and whatnot. It came to a point that we said, this is too much for us to handle. And so it went into, hands of people from Laie. I think that, if I really wanted to look at this bill, if I really wanted to look at this act, I would really think, gee, this probably would do good for a place like us in Kahana, where we really need a recreational center with a certified kitchen. Would really, really help us in Kahana, because we're not on commercial land, we're on conservation land. So this kind of would bypass everything so that we could get a recreational center with a certified kitchen. And it could do good for areas that maybe some of our senators have been trying to move because they're not able to get some of those areas in their district or mokus that they represent, get some of those projects completed. But I think that the bottom line to all of this is that they gotta listen to the concerns of our people. Every one of us that pay taxes that live in the state of Hawaii has a concern, whether it's where we live, in our community, outside of our community, in the state. Our issues need to be heard. I'll sum up with just this. When you did your new administrative rules, did you really take into concerns all those people that came forward, that provided testimony for you, even in your rule, in some of the administrative rule changes? And if you have not, with the new rules that have come up, and those that had the opportunity to come today, please take that into consideration, because it's not going to move any further than this legislative body. Because I believe that this legislative body, there's many of them that have approved this act that are running pretty iffy right now. That I think that thing will be huli. It'll turn this legislative session. So if you've done all you can to make sure that your rules and everything is in order, you shouldn't have anything to worry about. But if you have not, I think that this will be the legislative body that will overturn it. They need 2/3, and I think that they will do it. Thank you very much.
D'Angelo? And then Ahmad. And anybody else want to sign up to testify? Go ahead.
Okay. Hello. My name is D'Angelo McIntyre. Thank you for opening the thing up so I could testify. I am originally from Louisville, Kentucky. That's where I was born. And when I say that I'm from there, I have the pride of saying that my ancestors are really from there. I'm part Chickasaw Native American, as well as African from the slave trade in the area. And I've always liked, having a connection with the land. But I do have to contend with the fact that that's really not my land or my people's land anymore, or they're not even there. That belongs to the United States government forever. So that's the end of that. But when I come here, and I met a guy and I fell in love with him, and I learned about his culture, and I learned about where he comes from and what he's going through. And I realized, my brothers and sisters over here, they still got something, because there is no treaty of annexation, like what Auntie was saying earlier. And whenever things like this pop up where they want to do things, for the state, I always have a problem with it, because it's technically not a state. Everyone knows the past and what happened. They came here with guns, and they pointed them at an unarmed woman in a palace with total disregard they threatened to level Honolulu. And that was pretty recent, I feel. 1893 is pretty recent. And here we are 119 years later, and we're just making all these decisions. What caused this to be here was Pono. And so I would like to, ask you guys to, consider that, because you don't have 67 state parks and 20 boat harbors. You stole that. That doesn't belong to you. When I say you, I mean the state of Hawaii. That's always been my big problem. That's why when I joined the Occupy movement, I put it out there to be de-occupy Honolulu, because my friends it's a nation in distress, and I can't sleep at night. I think that's why Americans have insomnia and need to take and have restless leg syndrome. You can't have that kind of heather around you and over you and just continue to live life normally. What's done in the dark comes to the light. Thank you.
Aloha, Christopher Kiliva Hoi Kioni, Camarillo. And this seems to be geared towards the PLDC, but if we look at the LUC and we look at DLNR shuffled off part of its responsibilities to the LUC. And the LUC's primary purpose is to carry out Act 187 and Act 100, which is to maintain the agricultural lands that are here. And the PLDC seems to go totally against that. And I don't know. I had one of my mom's friends like asking me, it's like, well, isn't it good? There might be a McDonald's like at the school that my kids go to. I was like, well, I don't know. It might be good for you. Bottom line, though, is just like everything that anybody can do is being put off onto nobody so that somebody might not do it. And this can't continue. It's very clear what DLNR's jurisdiction and what they're supposed to do is. It's very clear what the LUC is supposed to do and what they're not doing. And it's very clear, to me anyway, what the PLDC aims to do. And it does not line up with what the state plan is, which is what governs these different elements. It's not in line with what the city plan is, which also governs these elements. And I don't see how anybody in good conscience can like feel good about 4 people running an agency that looks to develop public lands and potentially impede upon private lands. It's too loosely worded. These rule changes are so manini. It's like, it's like, gosh, oh, let's go over to Koholave. Oh, well, we can't go here because there's an unexploded ordinance over here. But you guys can have Koho'olawe back. But you can't go over here. So is a PLDC just another way to get the DLNR and to get the LUC out of doing what their jurisdiction allows them to do and what they're supposed to be doing for the constituents of this city or just the citizens of Hawaii? Never mind the citizens of America. America's like 2,500 miles away from here. But really, I beg your pardon? Summary? Sure. There is no jurisdiction for the PLDC according to jurisdictional lines that have already been laying in the sand. Act 187, Act 100. It clearly defines what the rules are. PLDC does not fit into that. Why we're having this meeting and discussing the same stuff that we've been discussing for the last 20 or 100 years is clearly not getting through to the lawmakers that are creating these agencies.
Thank you.
Aloha mai kako, Hawaii koino, Klaitoi Makali Thompson, representing Oka Island for the behalf of the people of Hawaii. This is totally ever. Thank you for giving me this time and honor to express my feelings and condolences As far as the paddle represents broken trust, broken families, not even broken, it was like not even stolen, it was just like misinterpreted. Just like my mental illness I have, bipolar and schizophrenia. I try to go get on a job, they don't let me get on a job. Because what is terrorists threatening? I can't even policeman anymore. I only work for my mom, I only go to school UH, went to college. I only collect Social Security and welfare. That's not my pride and joy. It's not even my identity. My identity is looking at this picture. God's camera. I'm looking at God's camera right now. Shame. Real shame. I learned the arts of Hawaiiana. I'm not bragging or boasting. I'm hurt. I'm humbly hurt. Big time. But at the same time, the same token, I'm happy and proud. Because I only can cry so much. Because after all the tears, the waterfall fall down. I make my paddle strong. I make my heart strong for Mama, Kahana, and my people. I come from Tongan, Samoan's history. The Thompson line come from the cigar and Thompson cigar and the Thompson machine gun. I check my genealogy. I don't like samurai anymore. From 1988 to 2008, nobody liked me because they said I'm mentally ill. But I get God's love now. I love Akua. He's going to show me the way. The scriptures is true. And no matter what people think of other people, we need love. Aloha is aloha, not force. I don't know how can people work. I love poetry. I play guitar. I play piano. But my main concern is humanity. We all need love. We need to change the pu'ai, the principles in our heart. You got to be true with our core. And I'm not talking shadows about shadows. I'm talking about family and families and nation and nations. Mahalo, mahalo, and bless your souls. Thank you. Aloha.
Aloha, o wau ka pua kele I koa kamai. Noho mai au I ka aina o pula pula, ka awa wa waianai. Ke ia pepa, ke ia Act 55, heva, heva, heva loa. You know, I come from Waianae. I'm a homesteader. I'm blessed to be a homesteader. Very thankful for it. But this Act 55 got passed in 2011, and we weren't looking out for it. But today we are looking out at it, because today we recognize the consequences of what could come. I also recognize the value of the intent of Act 55 to try and bring revenue. You know, it was purported, you know, to look for monies to help our schools, to help our parks, to help our communities. But personally, as I try to keep up with all of the information that's coming out with Act 55, I see that it's more of a government partnership with private corporation benefit at the taxpayer's expense. And I say this because who has the monies to develop? Is it our local organizations? Is it our nonprofits that are actually servicing the people out of the goodness of their heart? Because you know, when you're nonprofit, when you're servicing your communities, when you're active in your civic clubs, in your homestead associations, in your community associations, that's out of love. Love and service, like Auntie Ululani had said, out of service to your community, to your fellow human. But acts such as these open the doorway for commercialization, to monopolize our lands, to capitalize upon our tax dollars, to further
further subjugate the locals of this Aina, of the Koko and without the Koko, because we're all locals. Whether you've come in and adopted our ways, the way that we love each other, we love our Aina, and we want to protect and take care of it. That's what we're talking about, our locals, our Aina, which we have a bond to, that Native peoples have a bond to, their Aina. Coming from Waianae, I see our beautiful Waianae Valley. We have organizations, Ka'ala Cultural Learning Center, more commonly known as Ka'ala Farms. This land, Hawaiian homelands, DLNR lands, Department of Ag lands, the state coming in a partnership with a corporation that has the monies to build and develop, to come into my valley, onto my Aina and my Moku, and build up something that we don't want. I've seen the flow chart. I've seen a little bit of the Waimanalo meeting, which I appreciate Senator Pohai Ryan for providing for us. But that flow chart to me, even as I saw, there's little pieces of community input. But the community input that's going to be disregarded, just like the input, the recommendations to the administrative rules that has been disregarded. I think those input, especially from larger organizations, more of the well-known organizations like the Office of Hawaiian Affairs, like Blue Planet, like the Sierra Club, even from the proponents, that those suggestions be put out and there be rationale as to why it's not implemented, why it doesn't work for PLDC. Because our concern is that with the exemptions, the waivers, the broad stroke of a pen that 5 of you have the power to do, that broad stroke of the pen is going to affect all of us. The fact that we only have one hearing on one island in one small room speaks for itself. That, to me, that totally demonstrates what PLDC is going to do. They're going to do whatever the heck they feel like doing, regardless of the community input, regardless of the justified rationale as to why things should either pull back, reconsider, or completely change. Now, when we're not paying attention to those knowledgeable people, which there have been many that want to work with you, when we're not paying attention and considering and including and implementing their mana'o, their strong suggestions, we're also opening the floodgates for litigation. So not only do we open the floodgates for litigation, we open the floodgates for discontented citizens of this fake state. So this should not be the one and only hearing. That in itself is a total travesty. So I ask you to reconsider and go to the neighbor islands. I think that much of the initial objectivity that you folks witnessed, I think maybe some of that has calmed down. Maybe we've become more informed about what you have and still need to do. And perhaps we can present ourselves in a way to which is more acceptable to you. But oftentimes, the things that we are left with leaves us with the behavior that you see. So I ask you again, especially for our neighbor islanders, to please go back and take a look at it. Please reconsider all of the mana'o of our more known and knowledgeable people. And this is a fake state. All of what they call ceded land is seized land. We do not have no true documentation of actual statehood of a treaty. So that is still a separate battle, but it's one that's always going to come up because it's still there. The apology bill acknowledges that. We have unresolved claims. So bear in mind that things that are done today, when the time comes, will be moot, because all that has been done since the time is illegal. Mahalo nui.
Anyone else?
Good afternoon, Mr. Hariguchi, Chair Aila, David Arakawa on behalf of the Land Use Research Foundation. First of all, thank you very much for the opportunity to comment on the proposed rules and strategic plan and flow chart. We would like to commend PLDC for providing a website and frequently asked questions and other information on the website for people to view, and for having, I believe I counted 6 to 8 public hearings on the rules. This is either the 7th or 8th public hearing, including the one on the neighbor islands. I believe on not public hearings, it includes the board hearings, includes the introduction at the board. So including board hearings and these public hearings, I believe it's between 6 and 8 hearings where the community had the opportunity to comment, so I commend you on that. We would note, however, by the testimony here and otherwise, that there are very many concerns that the public has, and we would respectfully recommend that PLDC seek to provide yet even more public information, and not only to the public but to the new council members. We would note that the council resolutions were passed by council members who will no longer be in office many of whom will no longer be in office on January 1st. Perhaps go back to the counties and explain the purpose and the objectives of PLDC, and also have information on your website and available to the public to answer the many questions that were raised here, good questions that were raised here by the public. We've reviewed the rules, and as you folks know, we have experience with government rules, and we would say that these rules, strategic plan, and the flow chart is not a mess. And in fact, right now, various different state agencies have the powers to lease or otherwise allow for the use of lands, and PLDC is a way to have one agency in charge of the use of state lands, which is right now under the jurisdiction of several different agencies with several different processes. So it brings it all home to one agency. And we would also note that this process and the PLDC is consistent and similar with how other states handle the use of public lands. We hope that the public will have ample opportunity to comment and participate in the board hearing. And it wasn't raised, it might have been raised earlier, but everyone is going to have the opportunity to testify at the PLDC board hearing, where all board members could be present, and these rules are brought before you. So everybody will have yet another opportunity to comment in front of the full board. In fact, these rules are more stringent than the land use process of many other agencies, including DLNR's lease process and DLNR's conservation district use application process, more stringent than the LUC boundary amendment process, more stringent than the HCDA or Hawaii Community Development Authority HCDA approvals. This is based on what's in your strategic plan and that flow chart, just looking at all the I guess process in the flow chart. Also more stringent than the Hawaii Housing Finance and Development Corporation, their 201H affordable housing approvals, which in this past year has agreements for over 3,000 affordable housing units. And your folks' procedures are more stringent than what they do, based on your strategic plan and that flow chart, and also more stringent than the Department of Hawaiian Homeland's project approvals, and there are other agencies that have similar exemptions. We just have a few comments on the strategic plan and flow chart. We support the listing of the various laws which are applicable to the PLDC, and I think by listing these laws, it would give comfort to the people who are concerned about the process. Listing that the PLDC shall comply with the EIS law, shall comply with the historic preservation law, shall comply with the sunshine law, shall comply with the wage and hour law, shall comply with the restriction on the sale of ceded lands, no sale of ceded lands, PLDC shall comply with the state law relating to contractors, and the PLDC must pay OHA any ceded land revenues as required by the HRS. These things are very important to have not only in the law, but in your rules, and also the fact that the PLDC will not sell any state or county lands, will not sell any state or county lands without the legislature's approval or county approval that's required. So you folks do not have the right, legal right, to just go ahead and sell any state or any public land. I think it's important that the public, you know, and everyone understands that. We also believe that the paragraph in the strategic plan relating to IAL might need to be revised. The PLDC should have the flexibility to support projects on state IAL lands. The current draft guidelines prohibit development, even agricultural development, on lands eligible for designation as important agricultural lands, or IAL. You know, this has several problems, 4 problems that we've noted in our testimony. It could prevent worthy public-private partnerships and IAL and agricultural projects on state IAL lands and other agricultural lands. Secondly, such a guideline is unnecessary as the IAL law already requires the Department of Agriculture and DLNR to identify, map, and designate all public lands which should be IAL. The current IAL law requires Department of Agriculture and DLNR to identify, map, and designate all public lands which should be important ag lands. That's in the law. And it also requires that the Land Use Commission designate all of those lands that are recommended by Department of Agriculture and DLNR. So the second point is that guideline might be unnecessary. The third point is the vague reference to eligible for designation is vague and ambiguous. We would note that the current law and the existing HRS 205-44.5, HRS 205-44.5, which requires Department of Ag and DLNR to designate, identify, map, and designate IAL. It does not use the term eligible. Okay, eligible creates a very vague term, and it could also embroil the PLDC in ongoing litigation relating to agricultural lands that are, quote, eligible, unquote, for designation as IAL. And lastly, we would respectfully recommend, on this point, we would respectfully recommend that this section be revised, in fact, to encourage public-private partnerships for agricultural projects which are consistent with the IAL law or which otherwise support the agricultural industry and which support the goals and objectives of the Department of Agriculture. So we feel that the PLDC should be encouraging projects that are recommended by the Department of Agriculture for state lands. I got a few other comments. The strategic plan and provisions should be consistent with the language of Act 55 and the statute. We understand, or we've seen that there are several changes in the language that are inconsistent, with the...
You are allowed to speak longer, so we're giving him the time. Okay? Just comment, please.
Okay, I'll try to wrap it up. The law provides that certain provisions be applicable to PLDC, and the strategic plan changes that language. Any changes to the language could delay the review of projects and cause litigation. Next, we recommend that the PLDC encourage partnerships with all businesses. We would note that the strategic plan only refers to small businesses, so that could cause confusion. And lastly, we would recommend that the draft flowchart should be revised to be consistent with applicable rules and procedures of other similar state agencies which deal with land use approvals. And we mentioned those: DLNR, LUC, HCDA. Lastly, with respect to Chapter 302, just a general comment. Lastly, The proposed PLDC processes and rules should reflect relevance, reasonableness, and appropriate understanding of the development and financing process, and we've attached proposed draft amendments. Thank you very much. Thank you.
The last speaker, is that organized? Does anybody else like to testify?
Okay, this closes the public testimony portion of the hearing. After considering your comments and other testimonies, and it should be decided to go ahead with or without changes, the PLDC will submit the proposed administrative rules to the PLDC board at the board meeting on Wednesday, November 28, 2012, for adoption with recommendations. Should the board decide to adopt administrative rules, we will send the rules to the Department of Attorney General for legal review. After the AG's approval, the PLDC will send the rules to the governor for final approval and signature. If above as described, the PLDC will file certified copies with the office of the Lieutenant Governor. 10 days after filing, the administrative rules will become effective and have the force and effect of law. So on behalf of the Public Land Development Corporation, we thank you for attending. And before I adjourn the meeting, I was wondering if Chair Aila had anything he'd like to add?
We allowed other people to go over, and I think that was pretty rude of you. We allowed other people to go over. You shouldn't have interrupted. Okay? You made your point. It's done. Meeting is closed.
Thank you for that comment, and a point very well taken. I did say at the beginning, if you know those of you who were here, that we'd take the testimony for everyone and play it by ear. Some were longer than others. We understand the sensitivity, but nevertheless, we thank you all for coming. The public hearing is adjourned. Time now is 2:20, say 2:20, 2:25. Thank you.